Item 17.
For reasons mentioned in the judgment, this civil revision petition is dismissed with cost.
May be elected by breaking mention action number 13, my lord. I have taken consent from other side, my lord.
13.
13.
What is your
Well,
prayer?
The second bill, ma'am.
We have some difficulty, my lord.
What is your prayer?
Come after vacation, my lord.
Number of times we have taken time, maybe last chance.
Heard Mr.
Take care, lord.
E.K. Azad, learned counsel for the appellant, who prays for an adjournment. Also heard Mr. A.U. Chaudhary, learned counsel for the respondent. Ground is personal difficulty.
Person,
Considering the ground that the prayer is made due to the personal difficulty of the conducting counsel, same is allowed. Let this matter be listed. 10th of
It may be fixed, my lord.
in the
I may not be here, my lord.
okay
After vacation, my lord.
in the
After vacation. my lord.
after due vacation on a date to be fixed by registry.
Oblet.
Oblet.
Meet please, Lordship. Back to mention item 19, my lord. Item 19. My lord, for substitution, my lord. Already on last occasion, Lordship was pleased to substitute them on legal heirs of the appellant, my lord. Today, I was supposed to file the titled memo of appeal. During course of the day, I will file, my lord. So, matter may be taken up after vacation, my lord. Before vacation.
Heard Mr.
And second.
M. Setia, learned counsel for the applicant / appellant, who seeks some more time for filing the corrected memo of appeal as directed by this court in earlier. The prayer is allowed. Let this matter be listed after vacation on a date to be fixed by registry.
Any date was kindly.
6th of February.
May I please, Your Lordship? In item number 5, yesterday we have filed our affidavit in reply. And the record may be called for.
Call for the affidavit. Item number 5.
In the same matter, item 5, I had filed my response, my lord, before the winter break vacation, my lord. That may also be called for, my lord,
Okay.
and for opposite party number 1.
Hearing DA, item 4.
May I please, Your Lordship? Your Lordship, record pass call for Lord Sandeep.
Yes, 10 copies there.
Yes.
This is a case, Lordship, where there are 10 witnesses are there.
Oxometer.
Oxometer, Lordship.
Who is for the petitioner?
One ASM Majumdar.
What is the impugn order?
Between order, my lord, page number 93. My lord. The prayer for filing counterclaim has been rejected, my lord. It is a purely question of law, my lord. Page number 93.
What is to be done now?
Absence of appellant. May come after the vacation. My lord. The appellant is absent.
None has appeared for the petitioner on call. Mr. M.Z. Kadir, learned counsel for respondent number 1, 2, 3 is present. Let this matter be listed on 5th of February.
Make the lawsuit. And for the petitioner, and the service has been completed.
Okay,
Absolutely, we are appearing here as for the respondents 1 to entry all the respondents. After having learned from the reference being made in the trial court also. We'll find the Bagala number today at the same time, they will be directed to furnish the copy also.
Putul, microphone কাম করা নাই নাকি? Check. Yes. Louder.
Yes, Lordship, here we have appeared here, we are going to find a Bagala number today. At the same time, we have, after having reference being made in the trial court, we came to know about the matter going on in the appear before this honorable court. Lordship, they may be directed to furnish the copy of the.
We have not received copy of,
My lord, it is a common that when the notice is issued, we have to annex the copy of the petition also.
have you received
Otherwise,
the,
they will not, the registry will not receive the,
We have not received the
Notice.
copy.
and both sides we did take steps by speed post and other also.
you furnish an additional copy? No, when they are saying, the council is saying that
No,
he has
that's-
not
that's-
received.
But we have also annexed the copy.
I'm not disbelieving any of you. I'm only making a request.
Yes, I will, sir.
Heard Mr. R.K. Jain, learned counsel for the appellant. Also heard Mr. S.A. Bakhtiar, learned counsel for all the respondents, who submits that he has not received the copy of the memo of appeal. Learned counsel for the appellant is requested to furnish a copy of memo of appeal along with annexure to the counsel for respondent within 2 days from the date of this order. Let this matter be listed. When we can list it? The records would be necessary,
Yeah, that's it will be called.
only miss case record. Or it is not necessary.
Let it be called.
Let the records of Miss J case number 74/2018 be called for from the Court of Learned Civil Judge Senior Division Dhubri Registry to take steps for requisitioning the record. Let this matter be listed on 11th of February.
Much obliged.
May I please, Your Honor? This revision petition is referred against the order dated 18/7/2024, page number 47. What happened, the present petitioner has preferred a divorce case before the family court, Kamrup at Guwahati, and stating that his marriage was solemnized on 12th of May 2017. After that, the respondent, the wife, has tortured him, and she was always compelling him to stay separately from his paternal home. And on being refusal, but the lady has filed several police cases against the present petitioner and his family members. On 16/6/2020, on the strength of the complaint filed with the respondent, police visited the house of the present petitioner and they were called for the police station. And the lady thereafter lady has started staying at her paternal home. On 17th of June 2020, the present petitioner and his friend went to the paternal house of the respondent to bring her back, but she has refused. In this way, she stayed separately from the present petitioner in a rented house near her office at Panjaberi area for 9 months. And thereafter, all of a sudden, she appeared in the house of the petitioner and started staying in the room separately from the present petitioner, which is the house of the father of the petitioner. She is staying separately in that house, in a room of the paternal house of the present petitioner. And thereafter also, she has continued tortures upon the petitioners and petitioner and his family members, and being unable to bear the tortures, his family members, the old and ailing parents, was compelled to stay in his elder son's house in Bangalore. And during that period, the husband, the peasant petitioners has filed a divorce case before the family court, number being, so in number being
1256.
1256, 2023. In this case, the respondent has filed her written statement and filed her counterclaim, praying for the impleading the other peasant petitioners, family members, including his old and ending parents and other family members. And she has filed a counterclaim. On the strength of the and thereafter, she has again filed another petition before the lower court as page number 32.
No, what is the impugn order?
Impugn order, then kindly peruse the page number 47, 48,
What
48.
it says?
On the, he has filed one petition for the praying for the installation of the separate submeter in her room, which was the owner of the father. And she also prayed for the she has
Putul.
filed two petitions. One petition is called she has filed two petitions, one for the counterclaim, implementing the other, praying for the implementing the other peasant petitioners' family members, and another petition is 1344, praying for the installation of inverter connection in her living room in her matrimonial house, not disturb and cut electricity supply in the living room of the respondent, and to make arrangement for installation of the separate electricity submeter in the living room of the respondent. Lordship, the main question is she is occupying staying in a room of a father's house. The house is belong to the father, and father is the owner of that property, and electricity connection is in the name of the father of the peasant petitioner. Kindly peruse the page number 42. Assam Power Distribution Company, the
No, what this impugn order has done,
impugn has at page number
what it has ordered
ordered that
for installation of.
for I deem it page number 50, kindly peruse the page. After hearing the both sides, I deem it to direct the petitioner to make arrangement for installation of separate electricity submeter in the living room of the respondent, and also respondent has the liberty to install inverter in her living room by herself. Lordship, my question is this: whether the family court had any jurisdiction to direct the petitioner to install the separate submeter in the living room, because the property is the peasant petitioner has no right, title, and interest in the said property, and he has no share of that property. The family court has no jurisdiction to pass such order because the property is belong to the father of the petitioner, and the electricity connection is in the name of the father of the peasant petitioner. Section 7 of the Family Court Act, under Section
Family
7.
Court Act. Yes.
Family Court Act is jurisdiction, regarding jurisdiction. 7. Subsection E. A suit or proceeding between the parties to a marriage with respect to the property of the parties. Property of the parties or the either of them. I am not the owner of the property. My father is the owner, and he is not a party in that case.
Okay.
They have preferred the lady has filed a counterclaim for, kindly peruse the page number 48 of the impugned order. On perusal of the materials of the case record and after hearing the both parties, I am of the opinion that the counterclaim made by the respondent is not maintainable as the court has no jurisdiction to entertain application under section 18, 19, 20, 22, 23, read with section 26 of the Protection of Women from Domestic Violence Act 2000. And as such, the counterclaim made by the respondent along with the petition number 1729 is dismissed due to the non-maintainability and the respondent's liberty to file case under the Protection of Women from Domestic Violence before the proper forum or court. Honorable Court has rightly held that the court has no jurisdiction regarding the implementing the family members of the present petitioners. But on the other hand, has directing the present petitioner to install the separate submitter in the room, which is not his property. And I have no any share of that property. And without the taking the consent of the father, who is the owner of the property, has honorable lower court has the impugned order directing the present petitioner. So I humbly pray before this lordship to set aside that order because the family court has no jurisdiction to pass the order. That property is not the, I have no title, right title in the interest of that property. This is humble prayer.
May I please? Well, before going to minutes of the case, in view of the section 20 of family code, finally section 19 on, my lord. The instant revision plan is not maintainable, my lord.
Section
19 of family code.
yes.
My lord, kindly listen, 19 appeal, save as provided in subsection 2 and notwithstanding anything contained in the Code of Criminal Procedure 1908 CPC or in any other laws, appellant shall lie from every judgment or order not being an internal order of family court to the High Court, both on facts and law. My lord, they should have preferred an appeal against the said order of family court, not revision petition.
Okay. Suppose we treat it as an appeal, then on merit,
And one, the cost title of the amendment. And application under 20 of the Constitution of India and an application under section 115. My lord, huh? If they have preferred 115, then they should have preferred file the petition and within 90 days. Order was passed on, my lord.
no, your
18
first submission is that since the order is appealable order, revision does not lie.
Lie.
Okay.
And if then my lord could allow then man come to the, they should prefer the revision within 90 days from the date of passing order, my lord. They have preferred under section also 115 of the CPC. They have preferred file this revision petition after 8 months, my lord. Order was passed on 18/7/24 and CRP is filed on 11/3/2025. 2025.
Yes, anything else?
And my lord, come to me. My lord, my line claim that their property belongs to father. My lord, the respondent have not claimed the right title interest of the property. Just relief seeking relief interim measure. Since the date of marriage, she living in the backyard of the matrimonial house with the petitioner, my lord. And she just seeking file a petition for installation submitter and to inverter. They frequently disconnected the electricity in the living room of the respondent, not more than that. And she is ready to cause the for installation of submitter and will ready to pay the electricity bill as per meter rating, not more than that.
Okay.
Till the and divorce case is pending at evidences, not granted.
Yes,
Simple
regarding maintainability.
Maintainability section 19, last part,
Yes.
not being an interlocutory order, appeal last line is that seven as provided subsection two and not changing anything contained in the CPC. Version 1970 or in any other law, an appeal shall be lie from the every judgment and order. Not being an interlocutory order.
This is not but interlocutory.
This
just
is the interlocutory order.
interimism.
This is not the final order. This is
Interim relief,
Being
not
inter-
interlocutory.
So your revision is under what provision?
revision
Two
petition
twenty-seven or 115?
is 227 of the Constitution of India.
But in 227, why this court should interfere in mere error? Suppose court erred in exercise of powers under 227. The court has to be reluctant in interfering in all orders.
Lordship, the one court has no jurisdiction, without any jurisdiction has passed the order. That is why we have preferred the interlocutory revision petition before this knocking the justice of this honorable court. Without having any jurisdiction, the lower court has passed the order. It's on the same impugn order, the honorable court has held that this honorable court has no jurisdiction regarding the counterclaim filed by the respondent. And on the other hand,
This is separate, my lord.
no, I will just complete my. One hand, the learned court had below stated that they have no jurisdiction regarding the impleading the other petitioners because it is the this matter may be tribal and may be tribal under the DV Act. But on the other hand, the property which is not belong to the present petitioner and he has no share of that property.
Okay. Mr. What is your name?
DK Bodole.
D.K. Bordole, learned counsel for the petitioner. Also heard Mr. E. Ali, learned counsel for the respondent. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 18/7/2024 passed by the learned Principal Judge Family Court number 3, Kamrup Metro at Guwahati in FC Civil Case number 1729.
1256.
In the FC Civil Case number, you have mentioned
It
wrongly,
is the wrong leader. Typical typographical.
1256. 1256/2023. The brief facts relevant for consideration of the instant revision petition are that the present petitioner, who is the husband of the respondent, had filed a divorce application before the family court, which has been registered as FC within bracket civil case number 1256/2023. During the pendency of the aforesaid divorce case, the respondent had filed an application bearing number 1344/2023 /2024 on 14/6/2024, praying for installation of a inverter connection in the living room of her matrimonial house and a direction for making arrangement for installation of separate electricity submeter in the living room of the respondent. Stop. Learned counsel for the petitioner has submitted that the that the respondent, after some matrimonial dispute, had left the matrimonial home on her own on 16/6/2020. Stop. It is further submitted by the learned counsel for the petitioner that thereafter the petitioner went along with his friend to bring the respondent back to her matrimonial home on 17/6/2020. However, she refused to accompany him. Stop. It is further submitted that thereafter, after 9 months of the said incident, the respondent came to the matrimonial home and occupied one room and started living there. Learned counsel for the petitioner submits that the house in which the petitioner and respondent are presently staying does not belong to the petitioner, and it is in the name of the father of the petitioner, who is not a party to the dispute. He further submits that the petitioner does not have any share in the said property. Stop. Learned counsel for the petitioner further submits that the trial court had erred in allowing the petition number 1344/2024 filed by the respondent for installation of a separate electricity submeter in the living room of the respondent, in as much as the living room of where presently the respondent is staying does not belong to the petitioner, and petitioner he further submits that the electricity meter and electricity connection in the said premises also is in the name of the father of the petitioner. Stop. He submits that the trial court, the family court, under Section 7 of the Family Courts Act, does not have any jurisdiction to issue such direction for installation of meter in the residence which is not in the name of parties to the case. Stop. He also submits that along with the said application, the respondent had also filed a counterclaim seeking relief under Section 18, 19, 20, 23, and 22, 23, and 26 of the Protection of Women from Domestic Violence Act 2005. And same was rightly rejected by the trial court on the ground that the family court does not have jurisdiction to entertain an application under Protection of Women from Domestic Violence Act 2005. However, he submits that the trial court erred in allowing the petition number 1344/2024. Stop. On the other hand, learned counsel for the respondent objected to the present petition initially on the ground of maintainability of the present revision petition. He submits that in every order or judgment passed by family court is an appealable order under section 19 within bracket 1 of the Family Courts Act, and therefore the present revision petition is not maintainable. He further submits that even if it is assumed that the present revision petition is maintainable, still it would be barred by limitation inasmuch as the impugn order was passed on 18/7/2024, and the present revision petition has been filed after about eight months. 8 months. He also submits that as the present petition, the trial court was not wrong in allowing the petitioner, in directing the petitioner to install a electricity meter in the name of respondent, as there was allegation of
They have frequently,
disruption and of electricity supply in the living room of the respondent. Stop. He further submits that the respondent is ready to bear all the expenses incurred in the event of incurred for installing the electricity, separate electricity submitter in her name in the living room. Stop. In reply to the submissions made by the learned counsel for the respondent, learned counsel for the petitioner has submitted that the provision of section 19 within bracket 1 of the Family Courts Act is not applicable to this case, in as much as the impugn order in as much as the order which has been challenged in this revision petition is in the nature of interlocutory order against which no appeal lies. Stop. I have considered the submissions made by the learned counsel for both sides and have gone through the materials available on records. I'll pass the operating part in chamber today itself. And dispose of today itself.
Order, item 5.
Oh, we have not yet received the affidavits.
There is, told my lord, there is a notification of 23rd of December, wherein it is said, my lord, that there is an additional requirement of giving an undertaking that notice is served on all the respondents. So that is in the process which we are doing. That's how it has come.
My case,
Whether all the respondents have appeared.
I am the main contesting respondent, my lord. I am opposing the maintainability of the petition. This is a section 16 order passed under section 16.
Is there any interim relief?
Yes, there's an interim relief which is being continued against me, my lord.
Okay.
Third time, my lord, prepared.
No, have you served notice on all the respondents? Mr. Mishra,
Yes, my lord. All have received. All have received. There is a postal, this thing, my learned junior is there, he'll pass it on.
And the arbitration proceedings are going on, so all the parties
So we
are
can
aware.
hear the matter today if service is complete.
Yes, it can be heard.
Neither reading.
We will give extra copy which we have, my learned friend also can give, which they have filed.
You are appearing for,
And for number one, respondent number
how
one.
many respondents are there?
Well, there are
13 respondents. Excluding my lord respondent number one, there are 13 respondents.
So as regards other respondents,
You know, last time, if your lordship will see, your lordship's order dated 8th of December.
Yes.
Your lordship has passed an order. That's paragraph 8, my lord. Mr. A. Shandilya, learned counsel submits that he has been instructed by respondent number 3, 4, and 5 to appear in this behalf, and he will be filing his wakalatama during the course of the day. The learned counsel for the petitioner submits that as regards other respondent, notices have been served on them through dusty mode. However, he seeks some time to file affidavit in compliance.
have you filed this affidavit?
petitioner would be able to.
Well, the postal receipts are there and you file affidavit.
No.
Affidavit is not filed, but the postal receipts are there. Your lordship can see that. But I'm
No.
sorry,
The submission regarding service on the last date was that you have served the notices on other respondent through
Yes.
dusty mode,
yes.
and therefore the requirement of filing an affidavit in compliance was there.
Yes. Yes.
So have you filed the affidavit? in
No,
compliance?
we have not filed the affidavit because I am told, well, the instruction is that there is an acknowledgement from all the respondents whom we were supposed to serve. And, but then that should have been brought on record. But why that was not answered?
But office note says that regarding dusty service, there is
No, we are not taking this.
no steps, and no one is, who is assisting you?
My lord,
Nobody is there.
my lord should be there. Alas,
He has vanished.
That is the problem when you get cases from the outside chamber. But my learned friend is in hurry. I have absolutely no objection if it can be taken up. That I'm making it very clear.
Well, very simple point on law.
No, the preliminary question is
Yes,
Without-
that is there.
ascertaining the due service of notice on other respondent, whether we can hear this even on the question of maintainability. Your main plea is against maintainability of the CRP.
Yes. My lord, in fact,
My lord, if your lordship pass it over for the day, I'll check it and let it be listed tomorrow or day after, whenever your lordship is convenient. I'll get back. I
Is it
understand my learned friends.
Tomorrow I'm here. So,
Okay, we'll take it tomorrow.
My lord.
You ensure filing of
Yes.
affidavit.
My lord. In fact, that day I understood that Mr. Shandilya will file it.
He is appearing only for respondent number 3.
And 3 and 4. That I read the order, then I saw. But one Mr. Kaushik Jain is supposed to appear. He's not there. I'll ensure, my lord, in the course of the day, and your lordship will take it up tomorrow.
What is your name?
PJ Bora.
You are assisting Mr. Mishra.
Yes, my lord.
He is my junior, but he is not on record that way.
So we'll take it up tomorrow.
My lord, your lordship.
the service record is on its way, my lord, as per my friend.
Then we'll take it up at 2.
No difficulty.
If the
No, this is different. This is filing. let's not mix it up. This is filing, today we have filed the application, it is an undertaking to that which will be filed. That one, your lordship will take it up tomorrow.
Okay, okay. Heard Mr. D.K. Mishra, learned senior counsel for the petitioner, assisted by Mr. P.J. Bora, learned counsel for the petitioner. Also heard Mr. A. Foucault, learned counsel for respondent number 1. And Mr. A. Shandilya, learned counsel for respondent number 3, 4, and 5. Learned counsel for 3 and 4. On perusal of the office note dated 3/1/2026, it appears that neither AD card nor unserved notices have returned in respect of notices issued to respondent number 2 to 14 till date. Have you taken steps through Dusty mode?
No, not Dusty mode. Earlier, I think we have taken and the acknowledgement is there, has come. This is what my instruction is. We'll find it, Manoj, by today itself.
No, but if acknowledgement has come,
Yes.
it ought to have been reflected in the office note. But office note clearly says that no unserved.
We'll check up, Manoj, whatever is there, we'll check up. And tomorrow I'll let you know.
Learned senior counsel submits that he has been informed that the acknowledgement in respect of notices issued to the remaining respondent has been received and seeks some time to verify the same. The prayer is allowed. Let this matter be listed again tomorrow on 7th of January. Suppose the acknowledgement is not received,
Manoj.
then what will happen? Then can we hear the?
I have absolutely no objection. My learned friend has said he is the only respondent who is opposing. In fact, contesting
Okay,
respondent. is not
then-
the respondent.
Then we will be hearing the maintainability issue tomorrow.
Yes, then your lordship will hear the maintenance.
Before the learned arbitrator also, I was the only one, my lord, opposing the section
Okay,
16 application.
okay.
Even before the High Court also, you are the only one who opposed. Yes.
Last line ke likh le. For hearing on the issue of maintainability of the present revision petition
There's a fixed item in my lord,
as a fixed item.
particular time, if you not to-
What time you will prefer?
at any time.
At 2, is it okay, Mr. Mishra?
12
My lord, absolutely.
At 2,
Obliged, obliged.
at 2, fix at 2 p.m.
Deeply obliged. 6.
Yes.
Okay, Lordship, office note dated 15/12/2025 and T1/26 may be paid. As per 15/12/25, Lordship, the address he left, the payment, the address given, he has left the address, Lordship, and usual made was usual through usual course. It was the notice was could not be served because did not return, Lordship. Then Lordship, office note dated 3/1/26. Again, it says that await service report on usual process. So Lordship, but Lordship, the title suit which is pending before the Honorable Lordship, Civil Judge number 1, Junior Division number 1, the respondents are appearing through their Lordship counsels in every day, but still that they are not filing the written statement, Lordship. So we may be allowed, Lordship, to take steps on them through the learned counsel as per Lordship, order 3, rule 1 and 3, Lordship. Since they are appearing there in every day.
Heard. What is your name?
A.R. Tahvildar.
Heard, Mr. A. R. Tahvildar. learned counsel for the petitioner. On perusal of the office note dated 3/1/2026, it appears that the notices issued to respondent number 1 and through usual mode has not yet returned. It also appears that the scanned copy of the trial court records, which was requisition, have also not been received. Stop. Issue reminder for the scanned copy of the trial court records. Registry to issue reminder for the scanned copies. Learned counsel for the petitioner submits that in the trial court, what is the title suit number?
TS number Lordship 161 of 25.
In the trial court. No, the learned counsel for the petitioner has submitted that the respondents number 1 and 2 have appeared before the trial court in title suit number 161/2020-2025. However, they have not yet filed any written statement in the said suit. He submits that as the respondents are represented before the trial court by their engaged counsel, the petitioner may be allowed to serve the notice on the engaged counsel of the respondents under Order 3, Order 3, Rule 3 of the Code of Civil Procedure. The prayer is allowed. The petitioners may, the petitioner may, the petitioner may, the petitioner may take steps for service of notice on respondent number 1 and 2 by effecting the service by delivering the notice on the engaged counsel of respondent number 1 and 2 in title suit number
161 of 2000.
1631
Lordship.
161/2025. So in the event of effecting service by the above mode, the petitioner is directed to file an affidavit of compliance to that effect on the next date fixed. Let this matter be listed again on 11th of February.
Obliged, Lordship.
Item 7.
We have taken a step, but service is awaited.
What is to be done? You have taken steps by speed post. Okay. Heard Miss. What is her name? R. Begum, learned counsel for the petitioner. On perusal of the office note dated 3/1/2026, it appears that the service report in respect of notices issued through speed post has not yet been received. Stop. The registry is directed to place the postal track consignment report of the notice issued to the respondent number 1 through speed post on the next date fixed. Let this matter be listed on 6th of April. Miss D.D. Burman Learned, additional senior government advocate, appears for respondent number 2 and 3. The petitioner is directed to furnish the requisite number of copies of the revision petition along with annexure to the learned additional senior government advocate within 2 days from the date of this order.
Interim, continue.
The interim order shall continue till next day.
Next, please, Doctor. In this case, my lord, I was asked to file objection, but I could not file because the client is Calcutta, 80 years of age. Due to poll, he informed me he could not come to sign the affidavit. The lordship may had the petition on merit.
Today, you are objecting otherwise. How much delay is there?
Lord, it is 1,229 days.
9 days.
1, 2,
2 to 9 days.
9. 1, 2 to 9.
oh, it is a huge delay.
Huge days.
My lord, yes, my lord. And it is during my lord lockdown period, my lord. 2 years already extended for limitation, my lord. During lockdown, the case was dismissed for default.
But that judgment will not cover here because that judgment was, Somoto judgment was effective from 13/3/2020 to 18 March 2022. And that order was passed in between.
That is why it is.
That is why it is not 2 years limitation, they are not indebted. Because if the petition was dismissed earlier, then it will cover, they have got the 2 years time. Since the petition dismissed on 2011, 21, so that period they were not entitled to get money.
No, they will get some time exempt.
Lord,
From
sometimes
2000,
the
when,
Somoto judgment passed by the Honorable Supreme Court, it is 2 years time has been exempted from 13 March 2020.
15 March 2020.
20 to 18
28
March
28 February
2022.
22.
That order was passed, Iloswaka LDC. That order-
so from 18/11/2021 to 28/2/2022, that period will be exempted.
15 months get relief on that counter.
Yes,
exemption.
and remaining period you have to explain.
Yes, yes.
How much is the remaining period?
And remaining period, my lord, actually, my lord, my learned friend was the council, my lord.
It is 4
And-
months. Well,
Yes.
3 to 4. 3 to 4 months and more than 1.5 years.
Now, what is the reason?
Reason, my lord, the youngest council was left Guwahati during COVID pandemic. And he living in Borpeta. When the party received the notice from the executing court, and after getting that notice, he searched the website of the.
When you came to know?
It is, my lord, came to know on 11/4/2025, my lord. When the notice was served from the executing court, notice at page 12, my lord, notice was issued by the executing court. Notice issued on 24th March 25 and received that copy on 11/4/2025. And within 19 days, he approached this honorable court and filed this petition, my lord.
From the date of knowledge, my lord, it is only 19 days. There is no limitations. But if it is calculated from the date of order of rejection, dismissal on before, there is 1 to 9 days. And as per Sumoto,
What is the order of the apex court?
apex court, my lord, it is apex court, the my lord, only one copy is there, I am reading it. It is said after
You give me that order, I'll return it back.
my lord,
How you have explained 19 days?
90 days I explained, my lord.
90 or 90?
19, 1 9. One. I'll get it.
Where is the?
First book.
That 19 days also not explained.
Where is the explanation?
Explanation, my lord. There are 5, my lord.
No,
Five.
the time in between 11/4/2025 and 1st May 2025.
My lord, 15th March 2022.
No. You came to know about the dismissal order on
14.
11/4/2025.
Yes, my lord.
When you received the notice from the executing court. You filed the instant RSA on 1 May.
My lord, RSA filed earlier, my lord.
No.
1 May 2000.
This IA.
I have filed on 1st of May 2025. my lord.
So this gap, how have you explained? There has to be some explanation. Six.
Please explain, my lord.
Para 6.
There are 6, my lord.
Okay. Yes, Mr. Ahmed.
Generally, we are not objecting.
Then I am allowing it.
But in this case, my lord, you also can see the order was passed on 11/14, 18/11/2021. All the councils are appearing and that period of time also. It is not a case that no advocate has come. And explanation is that he is not come because other advocates are available in every day in this court, all online or also in presence. We are also appearing regularly. That
In the-
explanation has not been made. He said that just he went to the Barbeta 3 years.
What is the status of execution case?
Now, it is almost final. my lord. Almost, he lost page 12. Notice thereafter, he was called to ask and every person has been engaged. Just because of filing this petition, that has not been executed, finally executed.
My lord,
Illogical is moreover, my lord, in illogical appeal. There is a concurrent findings, my lord. Would the court will have dismissed their case, my lord. 15,80,000 is required to pay as a rent.
Heard. Mr.
K.
K.U. Ahmed, learned counsel for the petitioner, learned counsel for the applicant. Also heard Mr. J. Ahmed, learned counsel for the respondent. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant praying for condoning the delay of 1229 days in filing the restoration petition for readmission of regular second appeal number 82/2021, which was dismissed for default on 18/11/2021. Learned counsel for the petitioner has submitted applicant. Learned counsel for the applicant has submitted that the applicant had filed the connected regular second appeal number 82/2021 against the judgment and decree dated 23/10/2019 and 1/11/2019 respectively, passed by the Court of Learned Civil Judge Borpeta in title appeal number 2/2018, whereby the judgment and decree dated, it was reversed.
No, concurrent filing, madam. Godda Kullu has concurrently decided the matter.
Concurrent filing, but you have mentioned it wrongly in para 1 of your condonation of delay application. Dated 26/9/2017, passed by the trial court in title suit number 58/2014, was upheld. Learned counsel for the applicant has submitted that the aforesaid regular second appeal was dismissed for default on 18/11/2021 due to
Sorry, my lord, it is reversal judgment.
reversal,
My lord.
but he's saying
No, my lord, it is reversal.
I am wrong.
whereby got paragraph both, whereby the judgment and decree dated 26/9/2017, passed by the trial court in title suit number 58/2014 was reversed. Last paragraph case in. Appeal Katidio, reversed. Reverse. Learned counsel for the petitioner has Learned counsel for the petitioner has submitted that the aforesaid regular second appeal number 82/2021 was dismissed for default on 18/11/2021 due to non-appearance of the engaged counsel. Where is the MC? Miss Kesas. And accordingly, the connected miss case number 22/2025 was filed by the present applicant for readmission of the appeal. However, as a delay of 1 to 29 days was delay of 1 to 29 days occurred in filing the connected miss case, the instant interlocutory application for condonation of delay has been filed. Learned counsel for the petitioner has submitted that the appeal was dismissed for default during the prevalence of national lockdown due to COVID-19, and therefore the petitioner was unable to contact with his engaged counsel, namely Shahjahan Ahmed, who had left Guwahati and started living in its native place at Borpeta. Stop. He further submits that the engaged counsel of the petitioner never informed the petitioner, Jojot petitioner Kuriyasu applicant, the applicant, regarding dismissal of the regular second appeal. Stop. To the petitioner, to the applicant. It is only on 11/4/2025 when the applicant received the notice of the notice in the title execution case number 15/2020 from the Court of Learned Civil Judge Junior Division number 1 Borpeta. The applicant came to know about the dismissal of regular second appeal number, regular second appeal 82/2021. And immediately on coming to know, he contacted his engaged counsel and filed the restoration petition within 19 days. Learned counsel for the petitioner submits that though a total delay of 1 to 29 days have been shown by the registry, however, the period from 11/4/2025, no, period from 18/11/2021 to 1/3/2022
4 months.
would be exempted from the period of delay in view of the order of the apex court in the case of recognizance for extension of limitation within bracket miscellaneous application number 21/2022. He further learned counsel for the applicant further submits that as the applicant was unaware about the dismissal of the connected RSA number 82/2021, and he was relying on his engaged counsel who never informed him regarding said dismissal. The delay has been caused due to reasons which are beyond the, which were beyond the control of the present applicant. Hence, same may be regarded as sufficient cause which resulted in the delay in filing of the connected miss case for readmission of the RSA number 82/2021. On the other hand, no. On the other hand, learned counsel for the respondent submits that though the respondent initially took leave of this court for filing a written objection against the application for condonation of the delay. However, as the respondent is an aged person of more than 80 years of age and is staying at Calcutta, he was not able to come to the to Guwahati to sign the objection, and as such, the written objection could not be filed. Stop. However, learned counsel for the petitioner, learned counsel for the respondent has submitted that the respondent is opposing the condonation of delay of 1229 days, which is a huge period of, which is a no, for which no justified cause has been shown by the petitioner in his delay application petition. Delay condonation period.
Not properly explained.
He further submits that even if some period of delay is condoned due to the operation of the apex court's order in recognizance for extension of limitation within bracket supra, still the remaining period has not been properly explained by the petitioner in his delay condonation application. Hence, he submits that the said delay may not be condoned. Anything else?
And moreover, execution is finally finality, madam. Just because of this petition, could not execute it.
He further submits that the execution of the impugned decree is at a very advanced stage, and only for pendency of this present delay condonation application, the execution cannot be done. Stop. I have considered the submissions made by learned counsel for both sides. It appears that the order for dismissal of the connected regular second appeal number 82/2021 for default was passed during the prevalence of COVID-19 period. Hence, COVID-19 period stopped. It also appears that the judgment of the trial court was in favor of the present petitioner. However, same was reversed by the First Appellate Court. And in the connected regular second appeal, already substantial question of law has been formulated.
It is, yet to be
It is not yet admitted. I think.
It is not admitted.
Yes, my lord. At the,
Because the condemnation petition is there.
at the time
Earlier.
of admission hearing,
Earlier also there is a condemnation
Line,
petition.
A
judge
line to
condemned.
continue. Considering the fact that the delay has been attributed in the present petition due to lack of knowledge about dismissal of the connected RSA, as same was not informed to the petitioner by his engaged counsel, as well as considering the other reasons stated in paragraph number 5, 6, and 7 of this delay application app, of this condonation of delay application. This court is of considered opinion that the reasons shown by the petitioner may be regarded as sufficient reasons under the facts and circumstances of this case, which prevented him in approaching the court for filing restoration, filing petition for readmission of appeal within prescribed period of limitation. Hence, this court is inclined to condone the delay caused in filing the connected MC case number 22/2029. 2025. Accordingly, the delay of 1 to 29 days caused in filing the connected miscellaneous case is hereby condoned.
Subject to cost.
Yes, you pay some costs.
my lord, lump sum, my lord,
How much?
2,000, my lord.
5,000. Subject to payment of a cost of rupees 5,000
To the respondents.
to the respondent. Let the connected miscase be listed for hearing on. When will you pay the cost?
My lord, within 20 days.
20 दिन रुपीस. On 19th February,
Yes, my lord.
before, in
Before the registry, my lord.
January on 29th January, before the said date, the payment of cost to the respondent shall be condition precedent for hearing of the connected miscase on the next day. List according.
Since the petitioner would not come, that can be, council can be withdrew the amount and dispatch.
No, let us see how they deposit.
Obliged.
I didn't mind. And memo ready.
Wait, please, my lord. Lord, this application IA has been filed for grant of injunction, my lord, whereby my electricity was disconnected by the respondent landlord. But here, my lord, a subsequent development has taken place, my lord. The last occasion I was not aware.
Somebody repeating something,
Writ petition is preferred by the present petitioner, my lord, before this honorable court.
And what happened?
And that writ petition was disposed of, my lord, you may see at internal page 4, para 8. Accordingly, this court therefore disposes of the writ petition, thereby granting liberty to the petitioner to file application in proper format for electricity connection. And upon fulfilling the necessary requirements, the respondent authority shall provide electricity connection to the petitioner. It is observed and directed that Balkan source.
So you are withdrawing this.
I'm not pressing at the moment, but let it remain pending.
I application is withdrawn.
Let it remain
But my
pending.
lord, so far the case is concerned, it is mature enough. TCR is already there. Let it be heard finally, because there is concurrent finding of fact, my lord.
That
That's all.
CRP.
CRP already order was passed on the last date, my lord, that it will be listed for admission hearing after receipt of the TCR. That order is already there, so it will be listed, my lord. Today only the IA has been listed.
It is in orders column. We'll fix the CRP for admission hearing. And we'll reflect that he is not pressing this petition.
Yes.
Time being, my lord,
Why time being?
that if in future a need arises.
No, if the electricity is already disconnected, it remains disconnected. Why the time being, my lord?
Because it
Why
is his
time
duty to connect the electricity.
No. It is not my duty to connect the electricity.
Okay. Then we are not heard Mr. A. Iqbal Lanet Council into IA thobo. Heard IA CRP separate orders thobo. Heard Mr. A. Iqbal Lanet Council for the applicant. Also heard Mr. A. Sattar Lanet Council for the respondent. Lanet Council for the petitioner has submitted that the applicant has filed a writ petition bearing number WPC 7168/2025, wherein some orders were passed by the coordinate bench of this court. Regarding the provisions of electricity connection to the petitioner. And in view of the same, he is not pressing the instant interlocutory application for the time being.
Let it also be heard along with the main case.
So in the
CRP.
in view of the said submission, let this interlocutory application be heard finally along with the connected CRP.
My lord,
Start. 113/2025. In CRP, again, same party councils are same. On perusal of the office note dated 2012-2025, it appears that the records of the trial court which were requisitioned have been received. Hence, let this matter be listed for admission hearing when? 12th February. On 12th February.
Deeply obliged.
None has appeared for the petitioner on call. Let this matter be listed after vacation on a date to be fixed by the chair.
Item 11. Can you take up the arbitration act for this matter? Item 11.
Who is for the other side?
I'm for the appellant, my lords.
You are ready? Yes.
My lords, whenever you're ready.
Yes.
This is an appeal, my lords, under section 37 of the Arbitration
Arbitration,
Act.
Putul,
My lords, may I continue?
Arbitration Act.
I'm going to divide my submissions, my lords, in 4 parts. I'll just give a quick background to the matter, followed by the factual aspects. Then I'll read out certain important contractual clauses, and then I will end with my submissions. This is an appeal under section 37 of the Arbitration Act, filed against an order dated 26/2/2019, passed under section 34 of the Arbitration Act. Now, the subject matter of challenge before the section 34 court was an arbitration award dated 28/4/2016, passed by a 3-member tribunal. This arbitration award has effectively dismissed all claims of the respondent except the claim of liquidated damages.
Just a minute.
R. Chaudhary.
He's a son of my Ken.
That is not relevant for us. I don't.
Is it?
That is not relevant at all, my lords. I wish that was not brought up, but anyway.
Okay. Yes.
My lords, respondent was awarded a contract for a heater package for diesel hydro theatre project at Haligaon, Assam. The contract value was around about 18.72 crores. My lords, may just note a few dates. There are only a few limited dates here, and the case turns on those dates effectively. The letter of intent, my lords, was issued on 16th of August 2007. The scheduled date of completion of works under the contract was 15/9/2008, which was effectively 13 months from the date of the LOI. Important is the actual completion date, which is 10/8/2011. There is an admitted delay of 1059 days that the claimant took to complete the project works. 10/8/2011. So 15/9/2008 was the scheduled completion date as per the contract, but the works were actually completed on 10th of August 2011, 3 years later.
Okay.
Right from the beginning, the contractor sought extension of time because they were not able to finish the works for whatever reasons, and these extensions were granted subject to the right of the appellant to impose liquidated damages under the contract. Now, my lords may note that on 7/12/2011, after completion of work, respondent sought extension up to 10/8/2011, which is when they actually finished the works.
Yes.
Important is this date that I'm going to say right now, 19/4/2012. Now, at a time when the decision of the appellant on time extension and LD was not known, the final bill was submitted by the contractor to Indian Oil Corporation on 19/4/2012. This is the 24th RA bill. What is important here is that in this particular bill, no claims were notified by the contractor. The importance of this will become clear in my subsequent submissions. My lords, may for now may just note that 19/4/2012 is the date of submission of the final bill and also the date of submission of the no claim certificate, when they say that they have no claims against me.
Yes.
The next date is, the next important date is 28/2/2014. This is the date when we respond to them, allowing the extension of time up to 10/8/2011, subject to imposition of liquidated damages at 10% under clause 4.4.0.0 of the contract. So essentially what we do is, in 2014, we write to them and we say that your extension of time up to 2011 is granted, but because you delayed in completion of the projects, we are going to impose LD on you at 10%. This imposition was done under clause 4.4.0.0 of the contract. I'll read out these clauses subsequently. Last date that my lords ought to note is 10/9/2014. This is the date when the arbitration was invoked by the respondent on the ground that the imposition was LD, or the imposition of LD was unfair.
10% of,
10% of the contract value, my lords.
okay.
And the amount is 2.59 crores. The entire dispute, my lords, here is on the imposition of the LD,
Okay.
because all other claims have been dismissed. There were a total of 13 claims which were submitted by the contractor in the arbitration. Out of all these 13 claims, only one claim has been allowed by the arbitral tribunal, which I'll give you my submission in a nutshell. According to us, the arbitration was not maintainable because not even a single claim was notified as required by the arbitration clause. Despite that, the award was rendered in favor of the,
When it has to be notified,
it has to be notified during submission of the final bill.
but how they can notify, because you have imposed penalty
Correct,
in the year
except-
2014.
Absolutely correct. Except the arbitration clause, my lords, one of the foundational principles of arbitration law is that an arbitration clause is severable from the main contract. So the arbitration clause will survive the contract as well. So even if the contract has finished, say at a certain year in 2011 in this case, the arbitration clause survives. And because the arbitration clause talks about clauses 6.6.3.0, by extension, it is my submission that the other clauses also survive the termination of the contract. Therefore, if they had an issue with me claiming LD, I imposed LD in February of 2014. They invoked arbitration in September of 2014. They had approximately 5 months to notify me. They did not notify me. That is an admitted position on record. The award records that. The section 34 code records that. It is an admitted position on record that even the claim qua LD was not notified. So my submission is, I agree that at the time of, and I have to be fair to this honorable court, I agree that at the time of submission of the final bill, there was no claim because the LD was not imposed. I fully bow down. But my submission is because the arbitration clause necessarily survives the entire contract, the arbitration clause has to be construed as being valid and subsisting even after the contract has come to an end. So when on 28/2/2014, I informed them of my decision to impose LD of 2.57 CR, they should have immediately notified me as per the arbitration clause, because ultimately, my lords, what they have invoked in September is the arbitration clause. So if they have invoked the arbitration clause, they can't selectively invoke the arbitration clause.
Read 6.6.1.0.
Yes. Should the contractor consider that he is entitled to any extra payment of compensation in respect of the works over and above the amounts due in terms of the contract as specified in clause 6.3.1.0 hereof, or should the contractor dispute the validity of any deductions? This is important for us. Should the contractor dispute the validity of any deductions made or threatened by the owner from any running bills or any payments due to him in terms of the contract, the contractor shall forthwith give notice in writing of his claim in this behalf to the EIC and the site engineer within 10 days from the date of issue of orders or instructions relative to any works for which the contractor claims such additional payment or compensation, or on the happening of other event upon the contractor basis such claim. What is relevant here is, should the contractor dispute the validity of any deductions? I made a deduction on 28/2/2014. They disputed the validity of the deduction. What should they have done is prescribed in the clause itself, which is that they should have written to me within 10 days. They should have written to me within 10 days of 28/2/2014. That is my submission. And the reason I'm submitting that clause 6.6.1.0 survives the contract is because this particular clause has been resurrected through the arbitration clause itself, my lords. And because the arbitration clause itself says that every claim has to be notified, my submission is that this notification claim is independent of the final bill. And this becomes clear through even clause 6.6.3.0. Because if my lords just goes to the next page at 63, my lords will see that the requirement to submit the claim in the final bill is not conjunctive, is disjunctive. The contractor shall be separately included in the final bill, separately included. So even after the final bill was submitted, there was nothing, in fact, they were bound by the contract to give me a notice that we object to the imposition of LD. And why this is important, my lords, becomes even more clearer when my lords will see the arbitration clause again. Here, I would like to read one provision, which unfortunately is not a part of the record. And this is clause 9.1.2.0. My lords may just note 9.0.2.0. I will just read this provision, my lords. I'm really sorry, I don't have an extra copy, unfortunately. It basically says that it is the general manager of the IOC, of the appellant company, who has to decide whether a certain claim is a notified claim or not. So before arbitration is invoked, every grievance has to be addressed first to the GM. And I also have case laws to this extent. Arbitration can be invoked only once the general manager has taken a decision on whether a claim has to be preferred to arbitration or not. I'm going to read that out for your lordship's convenience. Any dispute or difference with respect to or concerning or relating to any of the following matters are hereby specifically excluded from the scope, purview, and ambit of this arbitration agreement, with the intention that any dispute or difference with respect to any of the said following matters and or relating to the arbitral tribunal's jurisdiction with respect thereto shall not and cannot form the subject matter of any reference or submission to arbitration, and the arbitrator or the arbitral tribunal shall have no jurisdiction to entertain the same or to render any decision with respect thereto, and such matter shall be decided by the general manager prior to the arbitral proceeding with or without reference, with or further with the reference. My submission is, it is established and well settled in law that an arbitration clause is severable and disjunct from the main contract. So whatever mechanism the arbitration clause provides for resolution of the disputes necessarily also survives the main contract. In this case, the works were completed in 2011. They submitted a no-claim certificate in 2012. I tell them in 2014 that I'm going to impose LD. Before invoking the arbitration, they could not have circumvented the mechanism provided by the arbitration clause. That is my submission. Now I want to show you how the award has dealt with this and how the impugned order has dealt with this. But before I do that, I want to quickly point out which provisions of law, according to us, are getting violated as to why we're seeking the interference of this 37 court. My lord, I have the Arbitration Act at page 33, section 34. According to me, this award is in conflict with section 34(2)(a)(4), section 34(2)(b)(1), and section 34(2)(b)(2), which is why, according to me, this is a fit case for interference, despite the limited jurisdiction. The other side will probably say that the 37 court is fairly limited, the court can't interfere this and that. But I am, according to me, there are three provisions of the section 34 which are getting violated here. And I want to read these out for your lordship's convenience. Section 34(2)(a)(4) says that an arbitral award can be set aside if the arbitral award deals with a dispute not contemplated by or not falling within the terms of the submission to arbitration, or it contains decisions on matters beyond the scope of submission to arbitration. The intention of this contract, the intent of the parties is very clear, and that is only notified claims will be arbitrable. An arbitral tribunal cannot wrongly assume jurisdiction over claims that are not notified as per the contract, that are not notified as per clause 9, read with clause 6 of the contract. That is my submission number 1 on subclause 4. On 34(2)(b)(1), 34(2)(b)(1), my lord says, this, if the court finds that the subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force, or if the arbitral award is in conflict with the public policy of India. My submission here is, arbitration, my lords, is the creation of a statute. Therefore, the arbitral tribunal is bound by the contract. The arbitral tribunal, my lords, cannot travel beyond what the contract permits or beyond what the contract contemplates. That's the difference between your lordships and an arbitral tribunal. So necessarily, the arbitral tribunal's jurisdiction is circumscribed to the arbitration clause. The arbitration clause is very, very clear. If you want to agitate anything before the arbitral tribunal, you have to notify. If you don't notify, then the arbitral tribunal does not have jurisdiction. In this case, according to me, the arbitral tribunal has done two things. Number one, wrongly assumed jurisdiction. And number two, in dismissing the other claims on the ground that they were not notified, has created a separate class for this LD. Here, my lords, please take page 147 of the arbitral award. This is akin to artificial discrimination under Article 14. Akin, not the same, obviously. Please take page 147. Actually, my lords, before 147, kindly take page number 158. I want to show you what the arbitral tribunal does, which according to us is in violation of public policy. Page 158 is the operative part of the arbitral award. So claim 1 basically is in respect of the running account bill. Now, my lords, I will read out the second paragraph at page 158, where the arbitral tribunal renders its findings from claims 2 to 10 and 12.
Yes.
The aforesaid claims in our view cannot be the subject matter of arbitration in as much as the same were not notified in terms of clause 6.6.0.0. Arbitration under clause 9.0.0 could only be in respect of disputes or differences arising out of any notified claim of the contractor included in the final bill in accordance with the provisions of clause 6.6.3.0 and or arising out of any amount claimed by the owner. Not only that the amount under the said claims were never demanded, but they do not form part of the final bill. So the arbitral tribunal, on one hand, in relation to every other claim, accepts that if you don't notify, you can't essentially arbitrate these disputes. Because even these claims were these claims were also raised after the final bill, by the way, my lords. Every single claim of the respondent were raised after the final bill was submitted and after the no claim certificate was also issued to us. So on one hand, the arbitral tribunal accepts that, look, you can't maintain these claims before me because you haven't notified. But for LD, the arbitral tribunal creates a separate class. The reasoning is at 147, which according to us is perverse. Please take page 147. This is the discussion on LD and the endeavor rather of the Honorable Arbitral Tribunal to create a separate class for LD. And I'm going to read this paragraph out, my lords. The main objection taken by Mr. Bakshi, learned counsel for the respondent, is that arbitration proceedings were not maintainable. He has referred to clause 9.1.0.0 of the GCC that contains provision for arbitration and submitted that arbitration is provided only for notified claims and not for any other claim. What constitutes a notified claim is to be gathered from the different subclauses of clause 6 of the GCC. Insofar as the imposition of LD by the respondent is concerned, we see no substance in Mr. Bakshi's objection based on notified claims. The next line is important, my lords, because according to me, this is wrong reasoning. It is apparent that under this head, the claimant is not asking for any additional payment from the respondent, and in that sense, it is not a claim. The respondent is objecting to the deduction made unlawfully from its bills by the respondent. My lords, if my lords will recall, clause 6.6.3.0 exactly talks about this. Deductions which according to the contractor are unlawful. This is in direct conflict.
Where is 6.6.0?
Yes, my lords. Page 62, my lords. My lords may please take 147 and page 62 together to compare it.
Disputes the validity of any deductions.
62, my lords.
Yes.
62,
yes.
if you see, 62 talks about the situations in which the contractor effectively has to notify. Now, there are two categories. Number one, where you are disputing the validity of any deductions made or threatened by the owner. This is fairly small.
So this LD comes within this.
Yes, according to us, this LD, and that is the definition of LD, my lords. LD is a deduction. Liquidated damages is a concept in law as understood under section 73 of the Contract Act or under this particular contract is essentially a deduction that you make for delays. Whether that deduction is justified or not is a different issue. But if you as the contractor feel that a certain deduction has been made and that deduction is unlawful, that's a claim. That is a claim that you have to notify. So the reasoning of the arbitral tribunal, humbly, my lords, according to me, is directly in contrast with the intent or rather the express language of my lords, express language of 6.6.1.0. I'm going to read the second part as well, my lords, at page 147. According to us, even that second part, with respect, does not make any sense. The respondent is objecting to the deduction made unlawfully from the bills made by the respondent. Since it is not a claim for additional payment, my lords, this line, since it is not a claim for additional payment, this reasoning, my lords, according to me, is perverse and directly contradicts what the intent of the contract is, my lords.
Against 6.6.0.
Yes, my lords. Sorry, my lords.
Now, what has been provided in 6.6.0?
Yes.
This observation is contrary to that.
Absolutely, my lords. I'm very grateful for my lord's observation.
That is your submission.
That is my submission. That is my submission, of course. Since it is not a claim for additional payment, there is no question of it being shown in any earlier bills and be notified to the consultant or to the respondent. The claim in this case has arisen after about 2.5 years of the completion of work and much after the expiry of the defect liability period, which expired on 9/8/2012. The tribunal is right. I also agree that the claim has arisen. Those are the facts I have to deal with. But my submission is, merely because the claim has arisen after a delay, does that defeat the arbitration clause? To that, my answer is no. The arbitration clause will survive for eternity because the arbitration clause is a separate contract altogether, which is devoid and distinct from the main contract. The main contract will determine the primary obligations, the rights and duties of the parties. But the arbitration clause is a mechanism that the parties resort to adjudicate their differences and disputes. And once the arbitration clause says you have to do A, B, C, D, you have to do A, B, C, D, because that is what the parties intended. The arbitral tribunal can't do something that goes beyond the intent of the parties, my lords. The claim in this case has arisen. So this is the only reason, my lords, why this appears to be this is the reasoning as to why a separate class has been created for LD and the LD claim has been allowed, while the other claims on account of not being notified has been dismissed. This is my point, my lords. I will now proceed to the impugned order, my lords, that of the learned judge, and show as to how, despite writing 150 pages, unfortunately, my lords, I struggle to understand. I personally struggle to understand the reasoning, my lords. My lords, may please take page 337.
Yes.
Right. At the outset, my lords, my first submission is the entire impugned order does not consider section 34 at all. It merely lays down the law. When my lords will see the award, my lords will realize that submissions were made with respect to section 34 before the 34 court. Submissions were made to the extent that, look, this award is against what the parties contemplated. The jurisdiction has been assumed wrongly, and three aspects of 34 are retracted. There is no discussion on whether which provision of 34 is retracted or not retracted. It simply goes on to reiterate what the tribunal says and then creates a class in section 9. I'm going to read out page 338, my lords. In the present petition also, learned counsel for the petitioner took the same plea in the first day of argument. In the later part of his argument, learned counsel took a U-turn by, God knows what this is, by taking the plea that this dispute was not fallen under the first part of section 9.1.0.0. According to learned counsel for the petitioner, it is fallen under the second part of the said clause. So learned counsel for the petitioner pointed out that the respondent already paid the money to the petitioner, which was deducted by the petitioner company as LD, adjusting the amount of the respondent claimed in the first bill. The arbitral tribunal rejected the other claims made by respondents, holding that those were not notified claims, but the arbitrators allowed the LD and the amount of so-and-so under claim 11 made by respondent. If my lords will permit, I'll read the entire paragraph, my lords. It will go to this second part of page 339. May I, my lords?
What is intended by the liquidated damages were not notified, or
No, my lords,
regarding
no
the
discussion.
requirement of notifying the liquidated
No, my
damage?
lords, no discussion to that
before-
extent. No discussion to that extent. In fact, I was just going to read out this line, my lords. So essentially, my lords, according to me, both the award, both the arbitrator and the section 34 court holds that LD was not a claim. According to both levels, according to both courts, the deduction is not a claim, and therefore there was no requirement to notify. That is my understanding, my lords, of page 147, which I just read out. And even at page 339, in the first para towards the bottom, my lords will see that as the dispute is not a claim, so different clauses of section 6 are not applicable.
Where?
The fourth line from the bottom, my lords, at page 339, first paragraph itself. Page 339, first paragraph, fourth line from the bottom.
Yes.
As the dispute is not a claim, so different clauses of section 6 are not applicable. Therefore, argument advanced by the learned counsel for the petitioner regarding fulfillment of procedure under 6.6.3.0 and 6.6.3.1 has no merit. So effectively, my lords, what basically impressed upon both the arbitrator and the section 34 court is that, look,
It has not discussed 6.6.1.0.
it has reproduced. It has reproduced it, my lords, but no discussion. The discussion, my lords, like I said, begins at 335. No discussion on the interpretation of this clause by the section 34 court, for instance. When I saw the number of pages, I was also under the impression that there's a lot of discussion. Unfortunately, I could not find any discussion except what starts at page 337, my lords. Everything else is reiteration of facts, case law, submissions, my lords.
No, whether the court. 34 court
Right, my lords.
had made any discussion regarding the clause 6.6.1.0 where it has been provided that should the contractor dispute the validity of any deduction,
Right.
this aspect, whether it has been discussed.
No, my lords. Like I said, the clause has been reproduced. But no discussion on this clause, my lords. The only discussion I could find, of course, my learned senior will probably might correct me if I'm wrong, but the only discussion I could find is at page 337. Before 337, my lords, no discussion. All reiteration of case laws and submissions, my lords. I've tried to. In fact, the clause is reproduced at page 272. My lords will see at 272.
Any observation how that clause does not cover the
No, my lords. According to me, no.
LD?
I'm adding the caveat, according to me, no, my lords. The only discussion is at page 337. The only semblance to discussion rather, where the learned judge holds that in the present case, learned counsel for the petitioner stated that in both kinds of disputes mentioned in clause 9, section 6 is required to be followed by the party who wanted to refer in dispute to the arbitral tribunal. In fact, what he does is what the learned judge does is the learned judge interprets section 9, clause 9, but there is no observation, no discussion, no finding on clause 6, which according to me was very, very important and frankly has become fatal to their case. Because clause 6 is very clear that a claim includes a deduction which according to the contractor is invalid.
6.6.1.
Absolutely, my lords, absolutely. So when the arbitral tribunal says that this is not a claim because it is an additional payment, or when the 34 court says that this is not a claim, what they are doing is directly going against the express language of the clause, my lords.
Yes.
And insofar as the delay is concerned, my submission has been that, look, you can't separate, you can't eliminate or extinguish the arbitration clause. That is always going to remain. And if that and that is what the Honorable Supreme Court has said, that is also what is the express mandate, my lords, of section 16 of the Arbitration Act, which is why our case from the very beginning was built on maintainability. Our objection that we filed in the arbitration was not just to the arbitration, it was also an application under section 16 objecting to the jurisdiction of the arbitral tribunal on the ground that not even a single claim that has been filed by the claimant is maintainable because you did not follow the procedure under the contract that you yourself signed up to. But unfortunately, that has been distinguished. A difference has been basically created between LD on one hand and the other claims on the other hand. Whereas all claims, my lords, were raised after the final bill. It is not even the case that the other claims were a part of the final bill. In fact, on facts, my lords, when we impose the LD as a counterblast, the arbitral tribunal records
So
this.
your submission is that LD also falls within same category
LD
as
absolutely, my lords,
none of,
second category.
as it was not notified.
Yes, my lords, my submission is LD falls within the same category, and regardless of when the claim is raised, my submission is because the arbitration clause provides for a mechanism, that mechanism has to be followed before you invoke the arbitration clause. That's all, my lords. If you don't, because party autonomy, my lords, is sacrosanct. The award, according to me, goes against the party autonomy as well, in addition to wrongly assuming jurisdiction. And this is how a case or public policy is made up. The other point, the last submission that I have is on section 73 of the Indian Contract Act. And this is also a point, this is also a point that goes to the root of public policy, my lords. The delay, and if I were to just give, my lords, few dates, few numbers rather.
Contract time.
Extensions, my lords, were sought since 2000, as on the contractual completion date, my lords, the progress was only 6%. For instance, in spite of 77% of work front being released. As on 27/11/2008, in spite of having 100% work front, the progress stood at 22%. The result of all this, my lords, is that the works did not finish on time. I had to then transfer the works to other refineries to finish the works, and I sustained losses beyond 100 crores. Section 73 of the Indian Contract Act entitles me to recover those losses through compensation. In that circumstance, my lords, what I did was only impose reasonable compensation of 10%. Therefore, in not recognizing that it is important to compensate a party for the losses suffered, it is my submission that the arbitral award is also against the express mandate of Section 73 of the Indian Contract Act, and by extension, in conflict with public policy. I'm going to finish my arguments, my lords, with 3 judgments, 2 of this honorable court and 1 of the Honorable Supreme Court on these issues, my lords. My lords, this is a judgment rendered by the Supreme Court in 2023 by a 2-judge bench, where the issue was very similar. I just want to read out a few paragraphs, my lords. 2023 2 SCC 539. My lords may just note the relevant paragraphs on the top of the page: 80, 85, 95, 96, and 97. I'll just read 2 paragraphs, my lords. I will not take my lords much time. Paragraph 80, my lords, at internal page 575. This is also a case, my lords, where a similar issue was at hand. The claims were not notified and the arbitration was invoked without notifying the claims. In fact, the appellant also was the same in this particular case. And therefore, the GCC that was applicable to my case was also applicable to this particular case. Anyway, these are all standard terms of contracts. Thus, I'm reading paragraph 80, my lords, at page 575. Thus, on a fair reading of the aforesaid provisions, it can be seen that only those claims which are notified after following the procedure as referred to herein above shall be considered as notified claim, and in respect of any claim other than the notified claim, the owner is not liable to pay, and as such is above absolved and discharged under the said clauses. 85, next para, 85, my lords. It talks about the entire procedure as to what has to be done when a situation like this emerges. On a fair reading of clause 9.0.0.0, which is exactly identical to our clause, my lords, only the dispute arising out of a notified claim included in the final bill in accordance with the provisions of clause 6.6.3.0 shall be referred to arbitration, that too subject to 9.0.2.0.
In the instant case, that notified claim cannot be included in the final bill.
Correct. I bow down. But arbitration clause still survives. So there was nothing preventing, because, my lords, the clause here says you either notify or you include in the final bill. So my submission is, look, before you invoke the arbitration, you should have notified me, because then what would have happened is the GM would have taken a call. There is a process contemplated under the contract before the arbitration would have been
He will
invoked.
decide whether the claim is notified or not.
Yes, my lords. That is how the contract has been framed. And unless they never challenged the arbitration clause, so they were bound by it. I would have, if I were them, I would have challenged the arbitration clause straight away before proceeding to the arbitration, because the GM can't be allowed to decide. But that is how the arbitration clause is worded. They have willingly signed it. Thus, on a fair reading of clause 9.0.0.0, only the dispute arising out of a notified claim of the contractor included in the final bill in accordance with the provisions of clause 6.6.3.0 shall be referred to arbitration. That too subject to clause 9.0.2.0, and any dispute matter falling within 9.0.2.0 shall first have to be decided by the GM. Because they did not notify, this step of 9.0.2.0 never came into fruition. So therefore, looked at from that perspective, my lords, it is also my submission that the arbitration, the invocation itself was premature. This was also a point urged before the arbitration, before the tribunal and before the 34 court, not considered at all. You could not have invoked arbitration without allowing the GM to first of all decide on the validity of the claims. And the Supreme Court says you can't do that. If my lords will see at the bottom of this paragraph, thus, unless there is a decision by the GM on whether or not a claim sought to be referred to arbitration by the contractor is a notified claim or not, the arbitrator or the arbitral tribunal shall have no jurisdiction to enter in such a dispute. I will not read the other paragraphs. My lords may just note the other paragraphs. At the end, the Supreme Court essentially allows the 37 appeal on the ground that, and quashes the award on the ground that the claims were not notified. Paragraph 96, perhaps, my lords, is instructive at page 579. on a conjoint reading of 9.0.1.0 and 9.0.2.0, it can safely be concluded that only the notified claims of the contractor included in the final bill of the contractor in accordance with the provisions of clause 6.6.3.0 shall be referred to arbitration. Whether or not a claim sought to be referred to arbitration by the contractor is a notified claim or not, the arbitrator or the tribunal shall not have no jurisdiction at all. I agree, my lords, it's a very peculiar clause, but it is a clause that both the parties have signed. And these are general contract, these are the terms and conditions under which the contractors agree to commence these contracts with these PSUs. Therefore, they are both bound by these clauses. Whether or not a claim is a notified claim or not shall have to be decided. Paragraph 16 onwards, my lords, the court has discussed the entire law on this issue and has come to a conclusion that without notification, the award can't be maintainable. And in 2015, my lords, paragraph 15 onwards. All the paragraphs, my lords, I would say are relevant because again, a full discussion of the law. My lords may frankly only see the 2019 judgment because the 2019 judgment also considers the 2015 decision.
Okay.
Let me go. My lord, first thing I submit to my lord that this is a claim. There were 14 claims, actually 13 claims, out of which claim number 1 is relating to RAB, which was allowed by the tribunal, upheld by the district judge. Secondly, my lord, the other claims 2 to 10 and 12 all rejected on the ground that my lord they are not notified.
Yes.
And claim number 11 regarding LD has been granted. And the cost has been granted separately. Now the question here is, my lord, here engineering charge was less. My lord, first thing, engineering charge is to see everything, my lord, whether extension is granted or not. This is the point, my lord, note point, my lord, my answer first, I shall situate that whether it's notified claim or not. Well, there is a question of notification. If your lawsuit see, my lord, first thing, 6.6.0, which is at page 62.
Yes, 6.6.0. 6.6.1.0.
6.1.0, 72, 62.
Yes.
Should the contractor consider the extra payment of compensation in respect of the works over and above the amounts in terms of the contract as specified in clause 10? Or should the contractor dispute any validity of any deduction made or created? Well, here LD is to be deducted every week delay 1%, maximum 10%. So they never deducted any LD while the contract was going on. They have to deduct LD at 1% per week.
No, the clause says that if you are disputing that deduction, then you have to notify.
No, that's it. I'm coming, my lord. During the course of the extension, my lord, if there is a delay, as per them, my lord, that on our part, then they have to deduct 1% as LD every week.
Every week.
Every week. And maximum is 10%.
Okay.
That's the matter. So now.
So they have deducted 10%.
They have deducted 10% of when, my lord? The contract is over in 2011. 2014, they have deducted. That is why I am submitting, my lord. Where is the question of notification, my lord? Notified. That
No,
is,
no, let me understand this.
Yes.
Assuming that they have deducted wrongly, but you are disputing that deduction.
my lord, they have paid, not deducted, my lord. We have to pay. They wanted to invoke the bank guarantee. Then we said that don't do that. Then we have to pay, my lord, that amount to them.
But that is by way of deduction.
No deduction. But we paid, my lord, by draft. We are paid by draft. So that they may not invoke the bank guarantee. Because by that time, my lord, there was only the final bill. Nothing is remained, 23 lakhs and all, that they can deduct, my lord. Except that nothing is there. There is no question of deduction more than that.
No, their case is that in on 28 to 2014, while granting the extension, post facto extension up to
10/8/2011.
10/8/2011.
Yes.
They granted the extension, but they imposed this 10%.
No, at that time they did not.
But that is the submission.
10/8/2011. My lord, that is the crux of the matter. I said, please, your lordship, but they have not filed any application under section 16 of the Arbitration Act. If they say that the court, the arbiter has no jurisdiction, they could have filed an application under section 16 of the Arbitration Act. They have not filed. Your lordship may just see section 16 of the Arbitration Act. They have not filed an application.
Let me just point out, my lords, we filed it on 18/12/2014, it's on record, my lords. We filed it on 18/12/2014, it's on record, the section 16 application.
Maybe.
Okay, yes.
Against that, no appeal in that case. Now, if your lordship see, my lord, that these deductions, whatever they say, notified claim, it is before the final bill is submitted. Because every notified claim is to be included in the final bill that your lordship find again. Your lordship see again 6.6.1.0. The works over and above the amounts due in terms of contract as specified in so and so thereof, or should the contractor dispute the validity of any deduction made or threatened by the owner from any running bills. So they have to deduct a running bill, my lord. They have not deducted a single paisa from the running bill, my lord. Or any payment due to him in terms of the contract. The contractor shall forthwith give notice in writing of its claim in this behalf to engineer in charge and the site engineer within 10 days from the date of issue of the orders or instruction relating to any works for which the contractor claim additional payment or compensation or on the happening of their event on the contractor basis such claim. And such notice shall give full particulars of the nature of such claim and grounds on which it is based and the amount claimed. The contractor shall not be entitled to raise any claim, nor shall owner anywise be liable to in respect of any claim by the contractor unless notice of such claim have been given by the contractor to engineer in charge and the site engineer. In the manner and with the time aforesaid, the contractor shall deem to have waived all the claims and all rights and respects of any claim not notified to engineer in charge and the site engineer in a manner in the time aforesaid. Well, engineer in charge, site engineer is no more there after completion of the work. There is no question of notifying them, my lord. Engineer in charge, site engineer ceased to be because the work was completed in 2011. Then 6.6.30. All or any of the claims of contractor notified in accordance with the provisions of so and so thereof shall remain or persist at the time of preparation final bill. The contractor shall separately included in the final bill prepared by the contractor in the form of a statement of claim attached thereto, giving particulars of nature of such claim and grounds on which it is based and the amount claimed, and shall be supported by copies, notices sent in respect thereof to the engineer in charge and the site engineer under clause 6.6.10. In so far as such claim shall any material particulars be at variance with the claim notified by the contractor within the provision of 6.6.1.1 thereof shall be deemed to have claim different from the notified claim and consequent in respect of the indicated in so and so, the consequence in respect of so and so. 6.6.3.1. Any or all notified claims not fully reflected and included in the final bill in accordance with the provisions of clause so and so shall be deemed to have been waived by the contractor. So up to final bill, my lord, is final. No question of notified claim does not arise, my lord. It is due to the period when the contract is going on. Well, am I
Okay, we'll continue. How much time?
shall take some time, my lord.
Okay, we'll continue at 2. Yes, Mr. Furqan. You have to inform the other side. Okay. Okay. You may make a mention tomorrow morning. We'll keep on it to 12 o'clock. Subject to the fact that you have to inform Mr. Mishra also. Okay. Okay. We'll allow it. We'll allow it tomorrow. Yes.
Calgary Lordship in regard to the last item of the list. Lordship, the other side is also there, we missed it to mention in the morning hours, Lordship.
Item number,
16.
16.
what is your prayer?
Lordship, taken up some other day, Lordship. Not this day of Lordship.
February.
February. We have prayer-
10th of February.
Heard Mr. K.R. Padgiri, Learned Counsel for the appellant. Also heard Ms. I. Das, Learned Counsel for respondent number 3. Due to paucity of time, this matter could not be taken up for hearing today. Hence, let this matter be listed on 10th of February. Yes, yes.
My lord, I should place a few paragraphs from the arbitral award, my lord. At page 147, I come now. Award starts at page 135. I am coming to page 1.
Yes.
Main objection taken by Mr. Bakshi, land counsel for the respondent, is that arbitration proceeding was not maintainable. He has referred to clause 9.1.0.0. It contains provision of arbitration and submitted that arbitration is provided only for notified claims and not for any other claim. What constitutes notified claim to be gathered from the different clauses, sub-clauses of clause 6 of the so-and-so. In so far, imposition of liquidated damage by the respondent is considered, we see no substance in the Bakshi's objection based on notified claims. It is apparent under this head that the claimant is not asking for any additional payment from the respondent. In that sense, not a claim. The respondent is objecting to the deduction made by unlawfully from the bills of the respondent. Since it is not a claim for additional payment, there is no question of being shown any earlier bill and notified consultant so-and-so. The claim in this case has arisen after about 2 and 5 years of completion of the work, much after expiry of the direct liability period, which expired on 9/8/12. We therefore find no merit in the submission of Bakshi that claim refund of the liquid damage is not a notified claim, cannot be subject to arbitration. In the light of the above, we are examining whether the decision recorded to levy liquidated damage was proper or whether claimant is entitled to refund the same. In so far as the imposition of liquidated damage is concerned, the case of the respondent is that it was because of the delay in completion of the work, the respondent had to levy liquidated damage. Later, the 28th February 2014, imposing liquidated damage states that approval of the competent authority to allow time to the claimant to complete is subject to within 10/8/11 was approved with imposition of liquidated damage amounting to be 10% of the contractual value as per clause so-and-so, so-and-so. It is thus clear that liquidated damages have been imposed because of the delay in completion of the work. If the delay is not attributable to the claimant, the respondent was not justified to levy the liquidated damage. However, if the delay is due to the claimant, the imposition of liquidated damage by the respondent may be imposed in accordance with the provision of the moot question, therefore, in the present case, whether delay was attributable to claimant. As detailed above and stated by paragraph 30 of the statement of claim, the claimant, there is a delay of 2.25 days is solely attributable to the respondent, and the claimant cannot be penalized for the same. The claimant wrought
a letter on 22nd August 2011 to the Engineers India Limited, giving details of the delays and the reasons which caused the delay, and requested AL to grant final time extension up to August 10, 2011, the date of commissioning the heater package. Engineers India Limited duly considered the request and claimant and recommended for extension of time up to 10/8/2011, without any financial implication on either side. On these, receipt of this recommendation, the respondent on 10/8/11 gave its observation on the recommendation made by EIL. It was stated that the chart was not intended showing plan versus actual time requested against all the activities to see the impact of delay against the individual activity on overall completion of the work. Delay analysis should be done activity-wise as appeared in the bar chart. And since that, as per GCC, force measure does not apply to the rain and band, therefore the delay against those items as mentioned in India's recommendation were not applicable. Engineers India Limited duly considered the observation and wrote back to the Indian Oil Corporation that no delay was considered by it under the 11th force majeure clause of the GCC. However, delay due to rain and band strikes did not find any effect on the overall delays as the same get overrun by other delays. The Engineers India Limited also enclosed the bar chart as were demanded by the respondents. Respondent again wrote to Engineers India Limited on 4/5/2012 seeking clarification on certain delays and recommended by the Engineers India Limited in turn some points taken by the respondent may be read under. Kindly refer to the above correspondences and discussions on the subjects above subject. Your letter so did not cover the queries raised by your discussion which were mentioned below again for your clarification. Actual completion date kindly justify the date of job completion. Completion should be 10/8/11 due to commissioning as contractor's scope is up to testing of the heater and completion of work. The contractor is to provide commissioning assistance whenever unit is ready. Kindly refer to a time schedule where there is no mention of commissioning assistance. As mentioned in your letter, there was substantial delay by the contractor in mobilizing the and starting of site activities. This first lot of extra delay materials were delivered at site only on 14/3/2008 and site job started so-and-so. You have mentioned that the progress as on so-and-so is only 6%. Please inform the percentage in front of the release so-and-so. More than 8 months were required for fabrication and erection of the hot air duct after hold was cleared on so-and-so. In this connection, please inform the following. Reasons for taking 4 months in fabricating from so-and-so, where there is a shortage of plate side. Reasons for delay in release of so-and-so, 270 duct for hot air duct only on 24/10 when fabrication of the duct was completed so-and-so. There was inordinate delay in completion of the installation of the FD fan. In this connection, please inform the following. When the FD fan foundation was released on 2011-2008 and the FD fan was issued on 23/2009, when the fan was taken up in the 3rd week of March 2010, after 1 year, and should not link installation of FD fan with hot air because this delay following problem is low and rectification of the foundation was delayed. The delay, therefore, was not equal to IOCL. Reason why more than 3 months was required to completion of the so-and-so after completion of the rectification. Reasons as to why the FIM was issued as late on 14/5/2010 and 25/2010. Please inform whether materials were received that or the contract was not ready for erection job. It is seen that because of the delay in FIM, the problem with the actuator, as mentioned in your letter, the job related to FIM was completed on 29/6/10. Attending checklist EIL so-and-so raised on so-and-so. The contractor took long time in completing the checklist points as informed by the contractor in the letter so-and-so. The checklist jobs were requested by them on 16/6/2011. In this connection, please note that our cleaning box etc. are under contractor's scope and no additional time is admissible for the same. However, if a major structural modification was pointed out by the IOCL in September 2010, the same may please be informed the copy so and so. From the above, it is observed that jobs requiring release from the EIL ISCL was completed by 29/6/2010, except FD fan installation, which was delayed by the contractor, completed on so and so, 14/7/2010. Beyond this period, situation and painting job was pending. Installation materials were received at site by the contractor on 9/9/2010, and job was completed on 30/10/2010 with the pending job. Therefore, please verify, review why the delay from period so and so should not be attributed to the contractor. This was quite a few later exchange between the Indian Oil Corporation and NGS Limited. Repeatedly, IOCL sought clarification on one point or the other. NGS Limited duly replied to the EIL. EIL also gave sufficient reason as to why the claimant was not entitled to extension of time. Finally, the EIL wrote to the respondent as under. Though there was delay on the part of the agency to in procurement of the installation material, there were also front-related problem as agencies were found to be working in the battery emit area of the heater. One of the example is installation of the outlet heater at radiant coil of DHDT heater was under hot due to hot job of the transfer line near DHDT heater outlet portion by other agency. Refer to checklist so and so in connection with so and so. Then from the progress report, it can be seen that EPPL achieved construction progress of 97.6%, overall physical progress of 99.6% as on 15/11/2009 and 98.3% and 99.4% respectively on 15/6/2010. Progress report includes balance work as on 15/6/2010, including installation accounted for 1.7% of the total package. The delay in installation work in particular did not affect any subsequent activities as the utility supply was delayed. It may be mentioned here that heater contact is an individual contact scope at the time tune commissioning, and there is no separate time period for achieving the mechanical completion of extra contact. The final effective duty out of DHDT, it was carried out by so and so immediately on availability of utility. As mentioned in the earlier correspondences, EPL conducted the pre-dry out LPG preservation refractory without any extra cost so and so. After completion of the refractory dry out, the commissioning of the heater was delayed as DHDT unit was not ready. After completion of the catalyst loading in the DHDT reactor, the commissioning of the recycled gas compressor and commissioning so and so was commissioned on 10/8/2011 along with DHDT heater. In view of the above, recommended once again that final time extension paid up to so and so may be granted without any so and so. Despite the said recommendation, the Engineers India Limited, the respondent did not grant full extension of time as recommended by EIL and imposed liquidity remain. The question therefore arises whether respondent was justified in not accepting the recommendation made by the EIL. As already stated, on receipt of the recommendation of EIL, the respondent made certain clarification which were duly replied by the Engineers Limited, and the prolonged exchange of letters between the EIL and IOC. And EIL has finally wrote on 22/7/13 retaining the grant of extension without any financial liability. On careful consideration of recommendation made by the EIL, the queries and the clarification sought by the IOC, reply thereto given by the EIL, we find that the decision of the respondent in not accepting the recommendation by EIL was not tenable. It appears to us that the decision not to accept the recommendation of EIL for extension up in time up to so and so is without any reason. The decision in respect of not accepting EIL recommendation, in our view, is inherently flawed. EIL was not representative of the claimant. He was the engineer consultant appointed by the respondent as stipulated by the contract. He is represented by the respondent on the work site and closely monitored the day-to-day work on the site on his behalf. This recommendation has been above made with careful consideration. These recommendations therefore carried out greater weight. Would, in our view, be overridden for only good and positive reason. We do not find any reason, much less compelling reason, for not accepting the recommendation of EIL. We therefore hold that respondent decision not to accept the recommendation of EIL cannot be accepted on the facts and circumstances in view of the so-and-so fully accept the recommendation of the EIL so-and-so. My lord, this is the my lord. Now, if your lordship see, my lord, Bakshi submitted that in any case the grant or not to grant extension contract completion time with the priority of the respondent decision not to grant extension or holding the claimants responsible for delay cannot be questioned. The so-and-so invited clause for so-and-so. Within 7 days of the occurrence, my lord, clause 4.315. In every on occasion opinion, contractor need to delay in the commencement or conception of the work site at hand would entitle the contractor for any extension of the time specified in this behalf and the progress schedule. The contractor inform the state engineer and engineer charge in writing of the occurrence of the act, even omission, the commencement such occurrence. Therefore, in the event such suggestion of such act or even the fulfillment of the omission of the contractor is opinion, the extension of the time specified in the progress schedule at the job site necessary, the contractor shall within 7 days from the date of fulfillment of the aforesaid make a written request to the engineer in charge for extension of the time specified in the progress schedule, and engineer in charge may at any time prior to completion of the such period he considers necessary his opinion that such event omission constitutes ground for extension of time in terms of the contract, and such event so-and-so engineer in charge in his behalf as to extension necessary shall be subject to so-and-so. Then notwithstanding any provision so-and-so, the owner may at any time own initiative or the request of contract if satisfied the existence of justifying delay, extend the date of completion of the work of any item operated so-and-so as the owner may consider necessary, and the addition of the owner on the ground justifying the extension necessary shall be final and so-and-so. Upon such extension so-and-so. Now next page, my lord, your lordship is missing. Second paragraph, 157. In our view, the submission of Bakshi is unacceptable. 4.3.6 of GCC cannot be construed to give respondent unfettered and arbitrary power in regard to extension on the date of completion of the project. In a given case, country may not be able to complete the project scheduled that due to act of the God, due to reasons attributable to the respondent itself, which would be open to the respondent to include the grant extension, and on the top to deduct contractor's bill from a very substantial amount that liquidated damage. They are obviously negative. Moreover, on the merit found that imposition of liquidated damage by respondent was quite wrong, we accordingly reject the objection raised by on behalf of the respondent and not justified leaving liquidated damage equivalent to 10% of contract value so and so. So this is the meaning of that. Now claims are considered. Now, my lord, if your losses come to the district judge, my lord. So losses may come to my lord page 291, my lord. From the district judge judgment. Your lordship,
291,
291.
291.
Yes.
Yes.
Second paragraph. As apart from the list of chronological events, the claimant submitted final bill, running bill on 29/4/2012. It may be stated here that since EIL has recommended time extension without any financial liability on either party, the claimant has submitted 24th RA bill on 19/4/2012 and also an objection certificate on 5/11/2011 in the order to settle the issue. After about 2.5 years of the completion of the work on 10/11/8/2011, respondent had later dated so wrote the claimant that respondent had allowed the time to the claimant to complete the project within 10 with time position of liquidated damage amounting to 10% of contract value. Well, this is beyond the contractual period. With the imposition of liquidated damage amounting to 10% of the contract value, as per clause 4.4.06. Further, another letter that shows to threaten to encase the bank guarantee if the claimant fails to deposit the demand or liquidated damage. The admitted fact that petitioner has not denied the fact that it informed the claimant concerning responded the imposition of liquid damage for a sum of rupees so and so is after 2.5 years of the completion of the work, almost 3.5 years from the date of letter was made ready for commissioning by the claimant, the answering respondent. It is stated that demand for liquidated damage being a claim of the petitioner owner, the requirement of notifying the same in the final bill in terms of so does not arise. Even assuming but not admitting that even in respect of the demand of liquidated damage, the contractor is notified. Even then, in the instant case, claimant did not have an opportunity to notify its grievance against the demand of liquidated damage in as much as the final bill was already submitted 2.5 years ago. It is submitted that the contractual provision does not contemplate a situation where petitioner owner does not inform the contractor answering respondent of his decision of the alleged claims and represent.
This is the submission.
This submission, madam. But this is my first thing when after
No,
contractor.
but what court held?
Yes, court.
No, this is the court is reflecting the submission.
Well, I'm coming. It is submitted that contractual provision contemplates petitioner owner. Well, I'm. Now your losses may come to page 293. Last paragraph. 293.
Para, which para?
Last subparagraph.
Yes.
Thus, without prejudice the fact that petitioner owner's claim is not required to be notified as per clause 9.1.00, answering respondent says that the petitioner by his own wrong cannot have the right and liberty to say that LD is not attributable and is not notified and or included in the final bill. In regard to the answering respondent states that honorable arbitrator, upon due consideration of the materials on record, in terms of contract, arrived at the following finding decision, which is the answer. Well, I have already done. Then this is the facts, my lord. My lord, that we have deposited that amount, my lord, that is reflected by 303.
Three zero.
3. Now, this should have been a claim of the owner before the arbitrator. This, they could not have forced me to pay the amount. My lord, this is the, my lord. Because during the pendency of the contract, they have not imposed any LD. Because although they have power, my lord, to impose LD every week, my lord, that they have not done it. And decision regarding this also they have given later on, my lord. Because there was correspondence going on between EIL, my lord, their engineers India Limited, and the IOC. Even though delays were solely attributable to the respondent EIL, the respondent by later said, long after completion of the project and spared the defect liability period, imposed.
No, the question here is
Well,
the imposition of liquidated damage.
Yes.
Whether it amount to deduction under 6.6.
no, my lord, it cannot be, my lord.
Why?
Because at that time, there was no bill pending, my lord. Only the final bill was submitted, my lord, in 2012. And how it can be included in the final bill? There's no deduction. We have paid in, my lord, your lordship will find here. We have paid.
No, it was not included in the final bill.
Ah.
But the security which you have given in bank, from
is
that,
another aspect, my
there
lord.
would have been a deduction.
No, that is not a deduction, that is invocation of bank guarantee. That's another aspect of matter, my lord. Because they cannot keep it after completion of the, defect liability period, my lord. They
So-
should have returned it.
So what is your submission that?
Your lordship, you see, my lord, here, in the middle, we have, they have said, claimant left no option, but had to deposit a sum of 2.13 crore to avoid encashment of the PVG. Claimant stated the so-and-so grant of accession without in liability delay, see known so-and-so. Well, this is that.
So is it your submission that imposition of liquidated damage to the extent of 10% of the
Yes,
contract amount was not a deduction
no,
made under 6.6.1?
no. Because the contract was already expired, my lord, in 11. This must be in the, because before filing of submission of the final bill, it must be there. Because that is to be included, if it is notified, that notified claim is to be included in the final bill. Oh. Your lordship must see clause 6.6.2.
6.6.2. Which page?
Well, I'm. Page 275. Oh, 288.
288. This is part of the judgment.
Yes. Should the contractor consider that he is entitled to any extra payment or compensation in respect of work over and above the amounts due in terms of contract as specified in so and so thereof, or should the contractor dispute the validity of any reduction made or threatened by the owner from the running account bills, or any payment due him in the terms of contract. So this is my lord. The contractor shall forthwith give notice in writing of his claim in this behalf to the engineer in charge and the site engineer within 19 days from the date of issue of such order or instruction relative to the any work for which the contractor claims such additional payment or compensation, or on the happening of such event upon which the contractor bases his such claim. And such notice shall give full particulars of the nature of such claim, grounds on which it is based, and the
Now,
amount.
why this clause is not applicable? Why? 1, 2, 3.
This clause is applicable only when the contract is continuing.
Okay, that is your first submission.
Because, yes, because running account bill mainly.
Or any other payment.
Yes, or any other payment, at the time payment, my lord. Here payment was only final bill, my lord. They forced me to pay amount to 2.13 crore. And engineering charge no more there at the time, because engineering charge ceased to be there after completion of the work. Even, my lord, the defect liability period was over in 2012.
What is defect liability?
So, post,
No,
after
what
the
is defect liability?
1 year, my lord. After
No,
completion of the
where is the definition?
defect liability period is, it is not here. But,
The liquidate completion
my
of
lord,
the,
that is the question, my lord. Here, that is why provision has been made in the contract that the delay 1% per week, my lord, they can be deducted maximum 10%. So here, after completion of the work, there was exchanges going on between the engineer in charge, EAL, and the, my lord, owner. And thereafter in 2014, my lord, they have taken a decision and imposed the liquid treatment. Why the question of notified claim, my lord? It cannot be, my lord, it cannot be notified, because notified claim must be included in a final bill. Final bill submitted, my lord, 2012.
but till then, till 2000.
That could have been an owner's claim, my lord, as per
No.
terms and clause.
No, till 2000. 14, your final bill was not paid.
Not paid, that is another aspect, my lord. They have only,
They made a condition that though extension was granted up to 3 years, however, they put a condition that 10% will be deducted.
my lord, that is a condition. Here, my lord, arbitrator as well as the district judge, my lord, both find that owner's decision is wrong. EIL has clearly submitted all the, my lord, things. And that is why arbitrator has given a decision, my lord, that the not imposition of liquidated damage on the ground that the extension
no.
is granted subject to,
The question before this court is that
yes.
not as to whether the arbitrator or the court was right in justifying the delay.
my lord.
Question is for assuming the jurisdiction to arbiter the matter, prerequisite condition as mentioned in 6.6.1, whether those condition was fulfilled or not.
Yes.
The petitioner is claiming that the requisite condition of notifying any deduction was not made. And that is his simple objection.
My lord, my question is this, engineer in charge.
Yes, that is your plea that
He
by
is
that time there was no engineer
no
in charge.
engineer in charge, my lord. And moreover,
So
I have
this,
to include the notified claim in the final bill. So this could have been a claim by the owner, my lord, as per the arbitration clause. This could have been a claim by the owner only.
no, where is that it has to be in the final bill?
Yes, my lord, there.
It may also be after submission of final
No,
bill
no, no,
if
no, no.
a deduction is threatened.
No, here, my lord, the next page, 78 to 89, 6.6.3,
6.6.3.
any or all claims of the contractor notified in accordance with the provision of 6.6.1.0 thereof, as shall remain persist at the time of preparation of final bill by the contractor, shall be separately included in the final bill prepared by the contractor in the form of a statement of claims attached thereto, giving particulars of the nature of such claim, grounds on which it is based, and the amount claimed, and shall be supported by copies, notices sent in respect thereof to the engineer in charge and site engineer under clause 6.6.1.0. Insofar as the such claim shall in any material particular be at variance with such claim notified by the contractor within the provision of so and so, it shall be deemed to be a claim defined from the notified claim, considered therefore indicated in so and so. So it is to be included in the final bill, my lord. If final bill is paid, submitted, my lord, there no question of, my lord, any claim by the. This could have been a claim by the owner only. After defect liability period, after 2.5 years, my lord, of completion of the work, they forced me to pay the liquidated damage. So, my lord, my humble submission is this, my lord, that this could not have been, my lord, notified, my lord, because there is no question of engineer in charge being there or site engineer there, because the work has been completed and it could not have been included in a final bill because they have imposed it after 2.5 years of the completion of the work.
Okay.
And the running 24th running bill was on pending, my lord. That was in respect of 23 lakhs and all, that only could have been, not more than that.
You're relying on any authority?
Yes, I'm saying, well, several judgments are there, was super, well, I'm just giving it. I shall not in all the judgments, I have prepared a note also, my lord.
I have queries.
Yes, madam.
I'll put questions
Yes,
later on.
Now, my lord, I am relying on the three judges bench decisions, one or two judges bench decision. One is 25-2 SEC 417 and then 22 for SEC. I shall place a few paragraphs from 25 to 22 for SEC 116.
Okay, you have mentioned the relevant paragraph.
Yes, I mentioned. My lord, your
On
lordship,
on which point?
my lord, the jurisdiction of the, my lord, 34 and 37, my lord. Your lordship may see, my lord, because interpretation of the contract and evidence, my lord, within the jurisdiction of the arbitrator. Court cannot enter into it. Interpretation of contract and application of law, my lord. My lord, your lordship may come to this 2022-4-116, very short judgment, my lord. I shall place a few paragraphs from that, second judgment. This is also three judges bench different, my lord. Three judges bench different. Others are, my lord, all two judges.
Para?
Yes, para 15 onwards, my lord.
Para?
Para 15 onwards.
Yes.
This court also accept as correct the view expressed by the appellate court that the learned single judge committed a gross error in reappreciating the findings written by the arbitral tribunal, taking an entirely different view in respect to interpretation of the relevant clauses of the implementation agreement governing the parties. Inasmuch as it's not open to the said court to do so in the proceeding under Section 34 of the Arbitration Act by virtually acting as a court of appeal. As it is the jurisdiction conferred on the courts under Section 34 of the Arbitration Act fairly narrow when it comes to the scope of the appeal under Section 37, the jurisdiction of an appellate court in examining an order, setting aside or refusing to set aside an award is all the more subscribed by 34 is narrow, then 37 is more narrow. This is an appeal under 37. In MMTC Vedanta Limited, the reasons for vesting.
Here we are only concerned with the order of district judge.
Yes. District judge, arbitrator, that has to be considered by your also.
But as district judge has concurred with the
Well,
finding of the
arbitrator,
arbitrator.
that is why, my lord, your lawyer has to see that arbitrator finding also. Now, I'm in MMTC so the reasons for vesting such a limited jurisdiction in the High Court in exercise of powers under Section 34 that I explained so. As far as Section 34 is concerned, the position is well settled. By now, the court did not sit an appeal over the arbitral award and may interfere on merits on the limited ground provided under Section 34 to B2. That the award against the public, now public policy is also not there. Well, then later. As per legal position clarified so court prior to amendment of 1996 in 2015, a violation of Indian public policy so. I'm skipping over this matter. Now, your losses may next 17. In a similar view, the courts in Sukumar observed that the contours of the powers of the court under Section 34 is too established to require any reiteration. Even a bare reading of the Section 34 of the Act indicates the highly constricted power of the civil court to interfere with the arbitral award. The reason for this is obvious that when parties have chosen to avail an alternative mechanism for dispute resolution, they must be left to the reconciliation themselves within the jurisdiction of the decision of the arbitrator, and role of the court should be restricted to the bare minimum. Interference will be justified only in case of commission of misconduct by the arbitrator, which can find manifestation in different forms, including excessive legal perversity by the arbitrator. It has also been held time and again by this court that if there are two plausible interpretations in terms of conditions of the contract, there is no such fault can be found if the learned arbitrator proceeds to accept one interpretation against the other. This is the my lord. The Dyna technology Compton gives limitation of the court while exercising power under Section 34 Arbitration Act highlighted thus. There is no dispute that Section 34 of the Arbitration Act limits a challenge to the award only on the ground provided therein or interpreted by various courts. We need to be cognizant of the fact that arbitral awards should not be interfered with a casual or cavalier manner unless the court comes to a conclusion that the perversity of the award as to root of the matter without there being any possibility of alternative interpretation, which may sustain arbitral award. Section 34 is defined in approach and cannot be equated with a normal appellate jurisdiction. The mandate under Section 34 to respect the finality of the arbitral award and the party autonomy is to get their dispute adjudicated by an alternative forum as provided under law. If the courts were to interfere with the arbitral award in the usual course of factual aspect, then commercial wisdom behind opting for alternative dispute resolution would stand frustrated. In Parsa County, so-and-so, adverting to the previous decisions of this court, McDermott International, Rashtriya Ispat Nigam, wherein it has been observed that arbitral tribunal must decide in accordance with the terms of contract, but if terms of contract has been construed in a reasonable manner, then the award ought to not to be set aside on this ground, but it held so-and-so. It further observed and held that construction of the terms of the contract, well, this is important. Terms of contract is primarily for the arbitrator to decide unless the arbitrator construes the contract in such a way that it could be said that something that no fair-minded, reasonable person could do. It is further observed by this court that in the aforesaid decision in para 33, where the court is applying the public policy test to arbitration award, it does not act as a court of appeal, and consequently errors of fact cannot be corrected. A possible view to arbitrator on facts has necessarily to pass the muster of as an arbitrator is the ultimate master of quality, quantity and quality of evidence to be relied upon and delivers his arbitral award. It further observed that thus that award based on little evidence or on no evidence, on evidence which does not measure up to the quality of a trained legal mind would not be held to be invalid in this case. Similar view is taken by this court in Naib so. In Dyna Technology, in view of the, it has stated that, moreover, optimum number of judgments, this court has categorically held that court should not interfere with the award merely because an alternative view on the facts and interpretation of the contract exists. The court needs to be cautioned and should defer to the view taken by the arbitral tribunal, even if the reasoning provided by the award is implied unless the award portrays perversity unpardonable under Section 34 of the so-and-so. As identical line, the reasoning based on so-and-so, South East Asia so-and-so, and Oil India so-and-so. It is settled position that court can set aside the award only on the ground as provided in the Arbitration Act interpreted by this court. Recently, the court in Dyna Technology versus so-and-so interpreted the court so-and-so. There is no dispute that Section 34 of the Arbitration Act limits a challenge to an arbitral award only on the ground provided therein and on interpretation of various courts. We need to cognizant of the fact that arbitral awards should not be interfered in a casual or cavalier manner unless a court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of alternative interpretation which may sustain the arbitral award. Section 34 is different in its approach and cannot be equated with a normal appellate jurisdiction. The mandate under Section 34 is to respect the finality of the arbitral award and the party autonomy to get their dispute adjudicated by an alternative forum as provided under the law. If the court were to interfere with the arbitral award in usual course of factual aspect, then the commercial wisdom behind opting for alternative dispute resolution would stand. It is also a settled law that two views are possible. The court cannot interfere with the possible view taken by the arbitrator supported by reasoning. Moreover, optimum number of judgments of this court have categorically held that courts should not interfere with an award merely because an alternative view on the facts and interpretation of the contract exists. The courts need to be cautioned and should defer to the view taken by the arbitral tribunal, even if the reasoning provided by the award is implied unless such an award portrays perversity unpardonable so-and-so. In an instant case, we have a view that interpretation of the 11 clauses of the implementation agreement as arrived by the learned swing arbitrator are both possible and plausible view. Merely because another view could have been taken can hardly be a ground for the learned single judge to have interfered with the actual arbitral award. In a given facts and circumstances case, the appellate court has rightly held that when a single judge exceeded his jurisdiction interfering with the award and questioning the interpretation of so and so. This is the matter. This is three judges judgment and at the another 125 283 judges. I have given a note on this matter judgment also. Our High Court judgment is also there, matter one. Because interpretation of law and interpretation of the contract is within the jurisdiction of arbitrator. Unless there is a perversity which shock the conscience of the court will not. And the 25 two judgment, my lord, said that now after the amendment of 2015, my lord, it becomes more narrow, my lord. Because public policy is gone.
Yes.
So my humble submission, my lord, that the submission of the, I'm saying that after the imposition of the LD, we could have notified, the question of notification does not arise at all, my lord. That could have been a claim by the owner in the arbitral proceeding. They could not have, my lord, done that, my lord, this is absolutely without this. After 2.5 years of the completion of the contract, after more than 1.5 years of the my lord, the defect liability period. And that is why, my lord, the London arbitrator has allowed claim number 1, 11, and under, my lord, that's the cost of the arbitral.
It's Mr. Chaudhary.
My lord, I have given a, my lord, note also, my lord, on the judgment.
Note.
Note prepared by, my lord, on the judgments. Short, my lord, notes.
Oh, yes.
Well, I won't take much time, 5 minutes, 8 minutes.
Reply.
Yes.
One question you should address
Yes,
that,
please.
assuming that there is a requirement of notifying even in case of deduction, but the deduction was made after 2.5 years when there was no engineer in charge or site in charge, then how, to whom the notice could have been given?
Well, that on facts and on the contractual interpretation may not be correct. Until and unless the bank guarantee is returned to me, the engineer in charge very much remains in the picture. The role of an EIC, my lords, is not just to oversee the project. The role of the EIC is to effectively act as an intermediary between the owner and the contractor. In addition to overseeing the project, one of the fundamental duties of an engineer in charge is resolution of disputes and certifying final payments. So until and unless the bank guarantee is held by the owner on the recommendation of the EIC does not cease to exist as contended by the other side. That is absolutely fallacious, my lords. 2 points. Number one, the EIC exists. EIC will only stop overlooking the project because there is no project to overlook. But there is so much to do. Final bill was not paid till 2014. So the EIC was very much there. It is not the case that the EIC ceased to exist. All they had to do was communicate to the EIC that, look, this is the claim. My lords, I'll explain this again. But before that, I want to just address 2 points my learned senior friend has made. Number one, imposition of LD is not a deduction, and therefore there was no question of notifying it. This is his primary argument. And his secondary argument is that this is a claim that could have been made by the owner. My lords, will please take page 158 for a moment. The arbitrariness of the decision is very clear from this particular page. Let's assume for a moment that my learned senior friend is correct. The arbitral tribunal itself says that all claims were not a part of the final bill. My lords, I am reading the last few lines at page 158. While dismissing claims 2 to 10 and 12, the arbitral tribunal holds not only that the amount under the said claims were never demanded, but they do not form part of the final bill. they are thus not the notified claims in terms of clause 6.6.0.0 as well as clause 9. Moreover, we see that the said claims have been made after the levy of LD by the respondent as a counterblast. So the question now is, if every single claim from 1 to 13 were made after the final bill was issued, what was the basis of this discrimination between claims 2 to 10 and LD? Even on merits, we do not find any substance in the said claims and the claimant cannot be held entitled to the same. The claimant has not been able to show as to how there is a loss of opportunity. My lords, I'll explain the fallacy in the arbitrator's decision in very simple words. On one hand, the arbitrator says that claims 2 to 10 are not maintainable because they were not notified. On the other hand, in the same breath, the arbitrator holds that there was no need to notify the claim qua LD because that is not in the nature of a claim. That is in the nature of an additional payment.
Yes.
My lords, the whole very nature of LD is a penalty. The form does not matter. Whether you ask the contractor to pay the LD or you deduct the LD from an existing payment, the fact still remains, my lords, that LD is punishment. LD is a deduction. How you deduct is immaterial. Because the contractor will pay me. If the contractor does not pay me, I will deduct from the bank guarantee. And until and unless I hold the bank guarantee, can the contractor say that all contract is over? No. Therefore, my submission before your lordships is, number one, imposition of LD is very much a deduction which comes within the ambit of 6.6.3. Submission number two, the arbitral tribunal has in accepting that all claims were made after final bill was submitted, has treated unequals equally. I am unfortunately drawing a parallel to Article 14 because that is exactly what has happened here. The LD has been put on a different pedestal for no reason. Even the LD claim was made after the final bill was submitted by that logic. So going by the logic of the arbitrator itself, the LD claim also ought to have been dismissed because the LD claim was also made because the claim qua LD, the initiation of the arbitration was also can be seen as a counterblast. Therefore, if 2 to 10 were not notified, and on that basis, it was okay for the arbitrator to dismiss those claims, why was LD put separately? On that basis itself, it is my submission that this particular award is perverse, is devoid of reason. And the Section 34 code does not even go to any of that. My learned friend could not read a single paragraph that was an observation. There are no observations in the 156 pages the learned judge has written, unfortunately. And my last submission is that there is no question of the owner claiming anything. Owner could not have claimed the LD because the owner is in a position to impose the LD. What the owner could claim perhaps is damages. What the owner could claim perhaps, my lords, is risk and costs. Say in a situation when the owner will get the work done through somebody else because of the absolute incompetence of the contractor, like in this case, then the owner will say that, look, there is a risk and cost provision. I will now recover all the costs that I have spent through a third party. Those are the kind of claims the owner can maintain. There is no question of the owner maintaining a clause or liquidated damages. The prerogative to impose LD is on the owner. Whether or not the imposition are correct, whether or not that imposition is right or wrong is a question of merits. And my learned senior friend has spent majority of his time dealing on the merits, whereas throughout from the very first layer, our case was built on maintainability. And therefore I submit that EIC, first of all, does not cease to exist because the EIC will be very much there to certify the final payment. In fact, in 2014, when we wrote to them, it was the EIC who wrote to them. The EIC wrote to them, my lords. I did not write to them. The owner did not write to them. The owner never writes. It is the EIC who communicates on behalf of the owner. That is the EIC's job. So the argument that is projected before this honorable court that the EIC ceased to exist is wrong. That's it, my lords. I have nothing more to add. I'm very, very grateful.
In the contract,
Yes, my lords.
which provision empowers the IOC to impose liquidated damage?
0.0.
4.0.
Yes, my lords. I have few pages. I have just
Okay,
taken those pages.
I just wanted to know the.
Yes, my lords. 4.4.0.0. And my lords may also note two more provisions. In fact, my lords may just see my ground for that. My lords may just see page number 14 of the paper book. I can just read that ground. That should be sufficient, my lords. 14. For that, the learned district judge while rendering the impugn judgment dated so and so, has miserably failed to construe that the prescription enumerated in 4.3.5.0, which is to be read in conjunction with clauses 4.3.5.2 and 4. So and so. In other words, though the EIC is empowered under clause 4.3.5.0 to grant extension of time to the contractor, however, such decision is subject to the rider provided in 4.3.5.2 and 4.3.6.0, which stipulates that notwithstanding anything contained in clause 4.3.5.0, the decision of the owner in respect of extension of time on justiciable grounds shall be final. The final say, the contract gives the final say insofar as imposition of LD is concerned is on the owner on the recommendation of the EIL or of the EIC. So once LD has been imposed, that decision is final. If you want to challenge that decision, you please notify me. If I have rendered that decision even 10 years later, the arbitration clause survives. If the arbitration clause survives, then every single mechanism that the arbitration clause provides also survives by extension. Otherwise, my lords, it will be a very anomalous situation when the arbitration clause survives, but everything else that the arbitration clause talks about ceases to exist. That, my lords, could not have been the intention of the parties when the contract was entered into. Those are my humble submissions, my lords. I'm very, very grateful for your extremely patient hearing.
My lord, on this, my lord, your lordship wanted to see 4.5.00, which is at page 157. My lord, if there is any delay in the final, you are also possible.
Yes.
Final completion of the work beyond the date of final completion of the work or works proceed at the job site. As stipulated in the progress schedule, the owner shall, without prejudice to any other right of the owner in this behalf, shall be entitled to liquidated damage for delay 1% of the total contract value for each week or part thereof, for the works remains incomplete beyond the scheduled date of completion of the work or works, as the case may be, subject to maximum. It is a maximum. Well, so they have to deduct 1% for the each week, my lord. And maximum is 10%.
Which we have done, my lord.
So while the contract is going on, my lord, they have not deducted any LD, my lord. Each week, my lord, whether they have deducted, no. That could have been notified, my lord, immediately. But they have done it after 2.5 years of the computer contract. And there is no question of, my lord, EIL remaining there, my lord, so far this contract is concerned. And this is my money, my lord. He has got when I have to deposit the amount, my lord, 2.13 crore, because they wanted to invoke the bank guarantee. Illegally, my lord, they have retained, because after completion of the defect liability period, they should have released the bank guarantee. It has to release by. So they have arbitrarily done it.
Heard Mr. R. Chaudhary, Learned Counsel for the appellant. Also heard Mr. G. N. Sahewala, Learned Senior Counsel assisted by Mr. H. K. Sharma, Learned Counsel for the respondent. How many respondents are there?
One respondent. So
Respondent. Hearing concluded, judgment reserved.
very grateful, my lords.
Judgment will not be linked.
Kindly pass over time being. My senior is on late.
Yes, okay. Timing or you want any, because if we take up other matter, no time will be.
Alternatively, I have a prayer. Actually, it's a part-time matter.
Part-time matter?
Yes. part-time
Okay,
matter.
okay, then.
And lordship may, if your lordship want to fix another date, then a fixed date may be fixed at particular time at 2 PM or, because otherwise, after part-time, on several dates gone by, but till that we cannot.
You have submitted some written gist of your submission. What is the matter? MSc?
Only one, MSc appeal, only one thing is that pay and recover part, nothing else. No other plea in their appeal, only pay and recover, how to pay and how to recover. This is the thing. And we are waiting for some time. If time permits, Lordship, will conclude today.
Because we are
Only
also
on
eligible
small
to
issue
the
only, Lordship,
Okay, okay.
on a small issue.
Means-
We are waiting for something.
May it please also. This appeal also on narrow campus. Only thing is, Lordship will kindly see. Today I have verified the LCR, lower court record.
Yes.
The lower court record, I have seen in the claim petition, there is LTI. Lordship, the claimant has put their LTI. But in the appeal memo, in the cross objection as well as in the Ukalatnama, there is signature of the claimant.
So what is the submission?
My submission will be, Lordship, if the claimant has filed this claim petition before the tribunal itself, there should be signature of the claimant in the original claim petition. Lordship can verify the record, but the signature was not there in the LTI. Ukalatnama also LTI. Now in the cross objection, in the, as well as in the Ukalatnama, there is a signature of the claimant. I do not understand how it happens.
So
Because-
what you want to submit?
My submission to be, Lordship, there is some manipulation. Because otherwise, if there is no manipulation, it will not happen. Because if claimant has put LTI in the claim petition itself, now in the appeal, in the cross objection, they have filed signature. In the evidence and affidavit, they have filed signature.
No, this appeal is mainly,
Mainly on the ground that license of the driver was not renewed. It was expired and thereafter without renewal, vehicle was allowed to be plied by the owner of the vehicle. That is the only ground in this case. And Lordship will find in the judgment. Lordship can see the judgment at, it starts from it starts from page 11. Lordship, what?
yes.
I will take your Lordship directly.
There were 7 claimants.
Lordship,
Who put?
the Susila Devi. May I take your Lordship to the para 38 of the judgment? It is
Paragraph,
relevant to decide this matter.
paragraph number 38.
38.
Yes.
Lordship, got it. Though the opposite party number 1 insurance company has tried to prove that the opposite party 3 driver was not entitled to drive the offending vehicle and has examined 2 witnesses to prove the same. Based on the above testimony of DW1 and DW2, it cannot be held that on the day of alleged accident, opposite party number 3 was not entitled to drive the offending vehicle, as DW1 and DW2 are not competent person to prove the authenticity of the driving license. Opposite party 1 should have examined the district transport officer DTO Nalbari to prove the same. Lordship, got it?
Yes.
Now I will take your Lordship to the order of the tribunal. Lordship will find that order.
Lordship can see the lower court record NCR. Order dated 14/7/2016. LCR record, page 6. Of the order sheet, page 6. In the order sheet, page 6, Lordship, order dated
Yes.
14/7/2016.
Yes,
Lordship got it?
yes,
Now I'm reading, learned counsel for the claimant and opposite party member were present. Today is fixed for evidence of OP1. OP1 has filed a petition stating that at the time of LS accident, driver was driving the offending vehicle without a valid and effective driving license. Therefore, it is prayed to allow to file additional written statement to take the said plea. Peruse the petition and allow the same. A statutory defense available to the insurance company. OP1 also submitted an additional written statement. OP1 also brought 2 witnesses and the witnesses have submitted their examination in chief on affidavit. Learned counsel for the claimant has declined to cross-examine them. Hence, they are discharged without cross-examination. The learned counsel for OP has filed another petition praying for summoning the DTO, Nolbury, to prove the driver was not entitled to drive the offending vehicle. Peruse the petition and rejected, as the claimant did not challenge the witnesses of the OP and OP1 on the same, fixing 2816 for argument. So this is contrary to the para 38 of the judgment. What's you got it now?
yes, what was the observation in para 13?
In para 38 of the judgment, learned court has held that OP should have examined the DTO to prove that the driver did not have any license. Para 38, may I read again? Opposite parties should, last portion, opposite parties should have examined the district transport officer Nolbury to prove the same. Para 38, last portion.
Yes,
What's you got?
yes,
So this is a contrary to the record, the finding given by the learned trial court, that is the tribunal, member of the tribunal, is contrary to the record that insurance company, appellant company has filed petition to examine the DTO. And that has been rejected on the ground that already the evidence adduced by the appellant company to prove that driver did not have valid driving license at the time of accident. And the claimant has declined to cross-examine. And that is why our application to call the DTO has been rejected. Now tribunal has held that we should examine the DTO. Also got my point. So this is the finding given by the tribunal in the judgment is contrary to the record of the case. In this particular case, admittedly, the person who was driving the vehicle has a license, but that was not renewed on the date of the accident. Lordship will find page 6 of the appeal memo.
page 6 of the,
Appeal memo. That has been exhibited by the insurance company. We have also annexed that document along with the appeal memo. Lordship got it?
yes,
That is a letter from the investigator to collect the information regarding the license to the DTO. And the endorsement is return or intimation that DL number Iman issued in the name of Utpal Talukdar. He is authorized to drive LMB, MMB, HMB and PSB only, renewed up to 3/10/2006 to 2/10/2009. And DL number as per office record. Lordship got it?
yes,
Now, date of accident is 26/4/2013. Lordship can note it down. 26/4/2013. Now, another question arose. Now, Lordship, the
owner of the vehicle, in this appeal memo, file a cross objection. Not a cross objection, file an affidavit, evidence on affidavit. Not evidence on affidavit, evidence in opposition. Stating that he has appointed a driver after verification of the license and found to be valid. And that is why he have engaged the driver. And it is the duty as per judgment of the Supreme Court that owner is not required to inspect the office or the required to office, visit the DT office to verification of the record. If the license produced by the driver is found to be issued by DPO with signature and seal, license is have valid license, then owner has no responsibility to verify the DPO. And there is no question of violation of policy condition or allowing a person without driving license. But in the original tribunal, they have not adduced any evidence to that effect that he has verified the license. And Lordship is aware, this is an appeal and the provision is regulated by Order 41, CPC. Though in the Motor Vehicle Act and rules, there was no provision how the appeal will be disposed of. But division bench of this court has already decided that the principle laid down in CPC, Order 41 will be followed.
So what you want?
Order 41 is followed, then there is no provision of filing affidavit in opposition. That document affidavit opposition, Lordship will not look into.
That has to be under Order 41, Rule 27.
Order 41, Rule 27 to adduce additional evidence. And that document, which has been filed as affidavit in opposition, I can show to your Lordship.
So your submission is that that affidavit cannot be looked into unless there is an application under Order 41, Rule
Order
27,
41,
and unless same is allowed.
same is allowed. And same is to be allowed at the time of hearing. Order 41, Rule 27 petition will be allowed at the time of hearing of the appeal, not before that. And that application is not there. And there is no provision to file evidence on affidavit in opposition.
Yes.
Lordship will find at page 22, the affidavit in opposition filed by respondent number 8. Page 22 of the appeal memo. Lordship got it?
Yes.
That is by the Bhuvaneshwari Sharma. And Lordship, I may not mention because I should not make an allegation against any advocate after practicing more than 30 years in High Court.
Page 22 of the appeal memo.
Appeal memo. Not appeal memo. The thing, because page number is given according to appeal memo, it should be numbered as per direction by the registry. So I have given the page 22.
In appeal memo, there is no page 22.
No, appeal memo, there is no appeal memo. Appeal memo, we have given a number in the appeal memo. Thereafter, they have consecutively make it numbered. Page 22.
Oh, yes. The additional affidavit.
An affidavit in opposition.
Yes, what do you want to submit?
Lordship will find heading and affidavit in opposition filed by on behalf of respondent number 8. That is the owner of the vehicle. There is no provision in the Order 41 to affidavit in opposition.
So this should not be taken into consideration. Then how this court will come to a finding that license was?
Basically, in this particular case, when we have filed this appeal was admitted and stay was granted without any depository award. They have filed an application for vacating the interim order. That is also rejected by this honorable court. The application for stay was granted. Thereafter, they have filed a petition for vacating the interim order. That is also rejected without depositing stay has been granted. In this particular case, for benefit of the claimant, I may make a submission. Considering the fact the original claim petition, Lordship can see the original record. Claim petition, Lordship can see the claim petition. Today I have verified. Original record.
Yes.
In the LCR.
Yes.
Lordship can see the claim petition.
Yes.
Lordship will file LTI of the claimant. Lordship got it. LTI. And Okaltama in the High Court, there is signature.
Your lordship permit me to, your lordship may peruse the evidence on affidavit as well as cross-examination of the,
Also,
that has been signed by the claimant. Signature was put.
now Lordship, the division bench of this court, as per judgment of Supreme Court, SIT has been appointed. For all MSCT cases where where the accident occurred, SIT has been directed to be constituted by the police authority. SIT, Special Investigation Team. Because if this happens, who is the claimant? That is not ascertained. If evidence on affidavit, there is a signature. In the claim petition, there is no signature, these are LTI. How a person can be represented by a person?
Your lordship,
This is a case where the matter should be referred to the tribunal again to decide whether the original claimant is there or not, or someone has approached this honorable court as well as in the evidence on affidavit.
You have earmarked, flag marked the wakalatnama.
Now, I have not flag marked the Ukaltama, but I have verified.
Wakalatnama flag koribo. Okay.
Secondly, Lordship, in this particular case, they have filed a cross objection for enhancement of the award.
There's not a.
There is a cross objection filed by the claimant for enhancement of the award. I have to make the reply on the cross objection filed by the claimant along with the appeal. Already I have placed regarding I will place the judgment later on, but what has been given a finding by the honorable tribunal and the original order passed by this tribunal in the before judgment, I have shown that regarding examination of the DTO.
So what is your prayer?
My prayer is, Lordship, the finding given by the tribunal is perverse. That we have failed to examine the DTO is a perverse finding, contrary to the record. If Lordship, because this court this court has already held in another judgment passed recently by this honorable court that examination of DTO is compulsory to prove that license is fair.
No, but that was rejected by the trial court.
That has been rejected.
And you have never challenged that order.
We have not challenged, but the finding is perverse.
We can ignore that finding.
Lordship can ignore that finding. Lordship can ignore the finding because that has been rejected contrary to that already. Already the
The
evidence.
burden is on the appellant to
Lordship.
show that there are material to show that he is driving without license.
Yes.
How will you
That has been
relieve that
fulfilled.
burden?
That has been fulfilled by examining two defense witnesses. One is the insurance investigator who has collected the information from the DTO. That has been shown by me that license was not renewed from such and such date. That is not valid on the date of the accident. And that evidence was not cross-examined by the claimant. They have declined to cross-examine. So whole evidence will go to establish.
And one more aspect is that it is not a case of having no driving license,
It is a case where license was not renewed.
not renewed. For that, whether the claimant would suffer.
That is why, Lordship, I will place a judgment on this point.
When?
That on this point, I will place a judgment on these points. Whether third-party claimant will suffer for not having license. I will place a judgment to that effect. Before that, I am going to answer the cross-examination filed by the cross-objection filed by the claimant.
You will file written objection.
No. I will place judgment on this point. The query made by your Lordship that whether claimant should suffer for not having any license, claimant being third party,
No, not renewing, no, non-renewal.
Non-renewal license claimant, why the claimants would suffer after having the policy of insurance. I will give the answer to that effect by placing a judgment. Before that, I'm giving the answer to that cross objection.
Your lordship, in this case, the claimants have also preferred a cross
Cross
objection
objection.
for enhancement
For
of the.
enhancement. Okay,
So my learned friend want to reply on that.
yes.
The cross examination lordship will find salary slip at page 68, that is exhibit 3 and 5.
Page,
Page 68 of the LCF, exhibit 3, 5. Exhibit 3 is a salary slip, different salary slip. Page 68 of the LCF. Lordship got it?
Yes.
Lordship will find that as per exhibit, gross salary was 21,649. Lordship, there are two headings. One is deduction, one is gross salary, and another part is incentive. Because this is what the labor in FCI. This is what the labor in FCI. So there is two things. One is gross salary, one is incentive, and other part is deduction. Gross salary has been recorded as 21,649. Lordship got it for particular month.
this page 67.
There are three different pay slips. One pay slip, Lordship will find at page 68. One at page 61, one at page 66. Different pay slip has been exhibited. Like that, exhibit 3. 3.1 to 3.5. At page 68, Lordship will find, Lordship mark it, Lordship be by highlighter. Because it is necessary.
Page 68, pro forma of the service.
Page 68, Lordship, salary slip, exhibit 3.5.
Exhibit 5.
3 within bracket 5. Highlighter given mark for this. If Lordship allow me, I can flag mark and I can return it back. Wait,
August 12, Nikhil. August 2012.
Highlighter to be highlighted.
So your first submission is that the driver was not having valid license and the court came to a perverse finding after rejecting
The prayer
the
for
prayer for examination of
DTO.
DTO, but it observed that the opposite party number 1 failed to examine the DTO. Okay.
Secondly, the evidence adduced by the claimant to prove that fact was not cross-examined by the claimant.
So it is sufficient to prove that fact that he was without having license. And that was not considered by the tribunal. That is your submission.
December 12.
have market red flag mark. Different, Lordship, there are different pay slips. Up to Lordship, the April, he died on March. Up to April, he died on 26/4/2023. So in April 2013, there is a salary slip of 18,000. 18,251, because whole month was not working. That is why 18,251 gross salary. Total gross salary. Gross earning.
Yes.
And before that, that is 23,388. And one is 21,865. So my submission in this particular case, they want to project that the incentive received, because if labor works more than his capacity, the allotted works, he's get incentive. They projected the incentive received because of the additional work by the labor should be considered as a monthly income.
Yes.
My submission will be, let's say, the incentive cannot be considered as a monthly income, because it is not a regular income. That has been during cross-examination, the person who want to prove the salary slip said that when work has been done, additional work has been done, then they get incentives for additional work.
Okay. What is the basis of claiming enhanced compensation?
Considering the salary slip,
They are claiming that it is not according to the salary.
salary slip.
That is the basis.
Another thing is deduction. 50% has been deducted, considering that there is only one dependent, there is wife of the deceased.
Lordship will kindly see PW3, the Alam Ara Begum, who has proved the salary slip.
Yes.
Alom Ara Begum, Lordship got it. Because there is no evidence and affidavit of the death witness because he was summoned. He was a deputy manager
Yes,
of
what you want to show?
Alom Ara Begum, cross-examination part.
Yes.
Middle portion. He may got promotion under Mondal, Sorder, Exhibit 3.1, 3.12 are computer generated payslip. Lordship got it last
Yes.
5 line. Computer generated payslip. CPF is deducted from salary. Incentive is not part of salary. Lordship got it. Last portion. Lordship can mark it
Yes.
by the highlighter. Because it will come to the notice of this honorable court if highlighted.
Yes.
Incentive is not part of the salary. Exhibit 3.1, 3.12. Basic salary is rupees 10,300. If one carries up to 105 bag, he will not get incentive. Incentives may vary according to work. Income tax is deducted, but I do not have any information. If he does not carry beyond 105, he would not get incentive. There is a provision for family pension around 3,000. calculated on the basis of present salary. So his basic salary is 10,300. Lordship got it?
Yes.
And it carries up to 105 bakes, and he will not get it bake, he will not get an incentive. If he works more than 105, he will get incentive. So intensive is not a part of the salary. That is a earning for doing hard work. If a government servant also doing some additional work after duty, he is getting incentive. That cannot be considered as a salary. Some lordship person, I can, out of the code I'm saying, some clerks are working in the night time, they are driving auto rickshaw. This cannot be considered as a income for assessment of compensation, like this lordship. Secondly, they want to project that multiplier should be 15. But they have said that they will not argue on this point also.
No,
So I will not argue.
multiplier is correct.
I will not argue that. lordship.
Multiplier
It
is
is correct,
otherwise,
correct, 14, yes, it is correct.
okay,
So I will not argue on this point, lordship.
okay.
Regarding multiplier, I will not argue. Lordship can record it. Otherwise, lordship will.
Yes, sir.
No, while calculating, your lordship, in the cross objection, while calculating, 14 multiplier has been used, not 15. Calculation has been made,
But in the process,
but in cross objection, a ground has been taken. Yes.
You are not
I will not
touching.
press,
Oh,
no, I will
oh.
not press.
So my submission to be lordship in this particular case,
Regarding deduction,
deduction, lordship, one thing is very important. Lordship, may I take your lordship to the assessment part? Because I should be fair to the claimant also, because I am arguing for the insurance company. That is not the case, but I have to see it fair. Lordship will find the calculation at page 20, page 6, para 28 of the judgment. Lordship got it, para 28.
yes.
Exhibit 363738 pay slip of the deceased shows that gross earning including allowances in the March 2012 was rupees 21,000, in the month of April 19,000, and in the month of July 2012 15,000. In the month of October, his gross earning and including allowances is 20,000. According to Exhibit 39, in the month of December 2012, his gross earning including allowances is 15,000. According to Exhibit 310, in the month of February 2012, his gross salary including allowance was rupees 21,800. According to Exhibit 311, March 2003, his gross earning including allowances is rupees 23,388. PW2, Rakesh Singh has categorically stated in cross-examination that this was his colleague. This is work in the same capacity like him. His pay slip is 24,860 per month. His regular pay income tax in view of the above. If gross salary including allowances for the month of March 2013 is 23,000 is taken, the actual salary of the deceased, then annual income is rupees a month. I dispute that.
But you have not challenged.
I have not challenged, but they want to increase that amount. That is why I have to make the answer.
Okay.
I have to make the answer because though I have not specifically challenged this point, but because of the cross-examination made by the claimant, I have to give the answer. Because they want to increase considering the allowances received by the deceased before his death. Now I'll take your lordship again to the evidence to prove the exhibits by the claimant. That is
No, before that you come to the para 31 of the judgment.
I'll go there. There is an error in this particular case. Before that, lordship, one thing is very important I should point out. There is a mistake committed by the tribunal, though it may not be intentional. Lordship will find tribunal has considered deduction of 50% from the income considered from the payslip considered 23,000, they are deducted 50% towards the personal expense of the deceased, which is not correct. Deduction of 50%, because in case of bachelor, deduction of 50% is considered a marriage prospect. Here, claimants are the wife and the children. So there cannot be deduction of 50%. That is an error.
Okay.
That is why I'm submitting lordship. I should be fair to the claimant also. Para 31 lordship will find.
Yes.
Para 31, it has been recorded. In the instance case, dependent family member of the deceased is a widow only. Deduction toward personal and living expenses, his deduction should be 50%, as his widow can neither claim nor entitled to more than 50%. That is wrong. Therefore, claimant is entitled to receive the remaining 50% of rupees 3,28,668. That is wrong, lordship.
Okay.
I agree to that. Because I cannot make any submission against the law, established principle of law. If it's a bachelor died, then parents are the claimant, then 50% is agreeable. But here claimant is the wife. So there cannot be 50% deduction. But only thing is, lordship will kindly see, because of the cross option, I have to point out that salary cannot be considered 23,000. It should be as per evidence on record, admitted by the claimant witness. Who was called to prove the salary slip. That is also basic salary of rupees 10,300. Evidence of the Alum Ara Begum.
Yes.
But tribunal has considered 23,000.
On the basis of salary slips.
Salary slip of a particular month. Of a particular month of 2012. Considering the incentive and other thing. That is the pay slip. There are 3 different pay slips, particular months. But which has been highest that has been considered. One pay salary slip slate 18,722. One pay slip slate 15,364. One pay slip slate 21,649.
Any other submission?
That's it. So my submission will be lordship in this particular case. The tribunal has considered the highest pay slip for assessment of loss of dependency, contrary to the evidence on record. It may be compared, 3 may be gross salary may be considered. 3 years salary, 3 months salary should be gross. Gross may be also considered, but highest should not be considered. That is my submission, lordship. Regarding lordship, the cross objection. Now I will place the judgment regarding the license.
Yes.
2009 8 SCC 785.
Yeah.
regarding Lordship, this is short judgment.
Which para you are relying?
Regarding finding of the court, Lordship, that is, Lordship, what has been stated. But may I point out before that, Lordship, placing the judgment, may I submit one thing? There is a controversy regarding pay and recovery. Honorable Supreme Court and division of single bench of this Honorable Court has stated that under Article 142 of the Constitution of India, Supreme Court has power to give a direction to pay and recovery. The High Court has no power under Section 142 to pass an order under Section 142 for direction to pay and recover the award from the owner. But Supreme Court has the power to give a direction to 142 power. The Supreme Court in this judgment has referred the matter to the Chief Justice to decide the matter finally, whether this 140th power can be used. Lordship, finding of the court in the first page itself, before reading the relevant portion. If the insurance company has no liability to pay at all, then it cannot be compelled by order of the court in exercise of jurisdiction under Article 142 of the Constitution of India to pay the compensation amount and later recover it from the owner of the vehicle. Article 142 of the Constitution of India does not cover such type of cases. When a person has no liability to pay at all, how can it be compelled to pay? It may take years for the insurance company to recover the amount from the owner of the vehicle. And it is also possible that same reasons the recovery may not be possible at all. Hence, direction was given that the papers of this case be placed before the Honorable Chief Justice of India for considering a larger judgment to decide this issue. And that matter has been para 7 of the judgment, that has been para 6 and 7 and 8. Relevant portion is para 6, 7 and 8. And it has been placed before the Honorable Chief Justice to constitute a larger bench to decide the matter whether 142 power can be exercised to when there is no liability.
What has happened there?
The full bench has not decided clearly. And Lordship will find another case that is reported in 2000. I will hand over the Lordship the judgment that is decided by Honorable Justice Manish Chaudhary. That is reported in 2019 3 GLT page 47, para 36. May I read slowly, Lordship?
What point you want to emphasize?
I want to place, Lordship has already pointed out in the initial stage that claimant being third party and claiming the beneficiary of the insurance policy, if an accident happens, claimant should not suffer. So claimant should be given the award and thereafter recovered.
No, my query was different. My query was, suppose a licensed driver was having a license, but when the accident occurred, the license, the expiry, date of expiry of the license has.
That answer I have already given the judgment. Lordship, para 11, that is Lordship, 2020, 4 SCC 221. That is Beliram versus Rajendra Kumar.
Yes, para.
Para 11. That is a appeal filed by the owner of the vehicle before the Supreme Court. On this point.
Yes.
Para 11, Lordship. The view taken by National Commission that law is settled in the PEFSHU case is not applicable in the present matter as related to third-party claim is erroneous. It has been categorically held.
Where are you reading?
Para 11.
We consider it appropriate.
No. The view taken by National Commission.
That is not para 11 of the judgment of.
Lordship, para 12, Lordship, para 12, that has been quoted. Para 12, Lordship. We may next advert to the judgment of the Nirmala Kumari's case. Judgment
Yes,
was
para
for
12.
para 12.
Yes.
Now,
In
directly,
that para 12, Some other judgments, para 11
Quoted,
is,
quoted, is in quoted.
yes.
While insurer can certainly take the defense that the license of the driver of the car at the time of accident was invalid. Fact, however, the onus of proving that the insured did not take the adequate care and caution to verify the genuineness of the license was guilty of willful breach of condition of the insurance policy or contract of insurance lies on the insurer. The view taken by National Commission that a law is as settled by PEPSU's case is not applicable in the present matter, as it related to the third party claim is erroneous. It has been categorically held in the case of National Insurance Company versus Saran Singh, para 110 that mere absence, fact, or invalid license, disqualification of the driver to drive at the relevant time are not in themselves defense available to the insurer against either to the insured or the third parties. To avoid this liability towards the insured, insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter fulfilling the condition of the policy regarding use of vehicle by a duly licensed driver or one who has not disqualified to drive at the relevant time. The submission does with that appellant as an insured has taken adequate care by verifying the license of the driver first respondent at the time of employment, and the liability could have been mulled on the appellant only if he was aware or had noticed that the license was fact or invalid, still permitted the person to drive. This was stated not to be the factual position in the present case, as the issuance of the license has not been doubted, but rather it was not subsequently renewed, which was pleaded to be the responsibility of the first respondent. Now, in this case, same, not renewed. We did not point out that at this stage itself by raising a query as how this judgment would help in this case at the appellant, since it was not a case of fact or invalid license. The appellant was required to take adequate care and caution to verify the driving license at threshold. Thereafter, the burden shifted to the insurance company to prove that such due care was taken. Could it be responsibility of verifying whether driving license was kept renewed? We are of the view that once the basic care and verifying the driving license has to be taken by the employer, though a detailed inquiry may not be necessary, the owner of the vehicle would know the validity of the driving license as it set out in the license itself. It cannot be said that thereafter he can wash his hand of responsibility of not checking up whether the driver has renewed the license. It is not a case where a license has not been renewed for a short period of time, say a month, as was considered by the Saran Singh, where the benefit was given to the third party by burdening the insurance company. The license at the instant case has not been renewed for a period of 3 years. That too, in respect of a commercial vehicle like truck, appellant showed gross negligence in verifying the sale. In this particular case also, 3 years it was not renewed. So ultimately, Lordship will find in last portion, para 21, learned judge debated the question of consequence of the MV Act being a beneficial piece of legislation. Thus, if two interpretations were possible, it was opined that the one which is in favor of the claimant should be given, but violence should not be done to clear and plain language of the statute. Thus, while protecting the right of the claimant by asking the insurance company to deposit the amount, recover the same from the insured would follow, as sympathy can only be for the victim of the accident. Right which has been protected is the right of the victim, not the owner of the vehicle. It was thus observed in para 18 as under. When an employee employs a driver, it has a duty to check that the driver is duly licensed to drive a vehicle. Section 5 of the Motor Vehicle Act provides that no owner or a person in charge of a motor vehicle shall cause or permit any person to drive a vehicle if it does not fulfill the requirement of Section 3 and 4 of the Motor Vehicle Act. Owner must show that he has verified the license. He must also take reasonable care to see that his employee gets his license renewed within time. In my opinion, if no defense for the owner is pleaded that he forget that the driving license of his employee had to be renewed, a person when he hands his motor vehicles to a driver owes some responsibility to the society at large. Life of innocent people are put to risk in case of vehicle is handed over to a person not duly licensed. Therefore, there must be some evidence to show that the owner had either checked the driving license or had given instruction to his driver to get driving license renewed beyond expiry thereof. In present case, no such evidence has been laid In view of the above discussion, I am clearly of the view here is a breach of terms of the policy of the insurance company could not have been held liable to satisfy the claim. So in this particular, so same thing, license has not been renewed for 3 years. Same, same thing, Lordship. So in this particular case, the license has been not been renewed. That has been down projected by if it is in opposition in the appeal. That is why I'm saying, Lordship, that cannot be considered.
Okay.
This statement has been made in the appeal in opposition.
Yes, Mr. Mandal. Anything else?
Lordship. Lordship, next 2009 8 SCC 785, para 3 and 5. लिख के रखना है। अच्छा। ये note करके रखो।
On what point?
Regarding Lordship to recovery of the amount by paying the amount to the insurance company from the owner of the vehicle. May I read slowly also? Prima facie, you
You mark the paragraph and give a copy to me.
Lordship, I'll give the copy. Same thing. Supreme Court has said, insurance company has no liability to pay at all. Then our opinion, it cannot be compelled by an order of the court in exercise of its jurisdiction under Article 142 of the Constitution of India to pay the compensation amount and later on recover it from the owner of the vehicle. In our view, Article 142 of the Constitution of India does not cover such type of cases. And this honorable court in 2019 3 GLT page 47 para 36. 2019 3 GLT page 47 para 36. May I read slowly also?
You have to wind up.
Lordship, then I'll hand it over.
You hand over that copy.
Lordship, para 36.
What was the observation?
Observation is that the power under 142 is on the Supreme Court.
Yes, on
Supreme
that
Court-
you have already made
Lordship,
submission.
this court has held that 142 power is not available to the High Court.
Yes, that is the law.
That is the law. I'll hand it over this to judgment.
Yes, Mr. Mandal.
Lordship. One thing, Lordship. And one judgment.
How much time will you take, Mr. Mandal?
Lordship, at least half an hour.
We cannot keep it part-heard. Remaining cases
No,
may
Your
not be taken up. So those counsel need not to wait.
Okay, one clear, my lord. Item number 14 and 15, my lord, there is a stay order, so lordship put it up today, my lord. Lordship, it is, we have filed a petition.
No,
we're
no,
getting the-
you try to understand.
Okay,
No,
This
okay, extension
No,
of-
week-
not today, my lord. Some lordship may fix a date, that is the only prayer, and let it come in the
We-
orders column, my lord.
We'll give dates, take dates from the court master. Fixed date, Didi. We'll give fixed date.
I'm-
In the part-heard matter,
Item number 10, part third.
we-
That may be on next Thursday.
Thursday is okay, Ms. Majumdar.
First item is a hearing. Yep, it's a prayer one.
Item number? Item number?
Item
Item
number
number 10. Due,
10.
due to paucity of time, this matter could not be taken up. Let this matter be listed on Thursdays,
8.
8th as part-heard matter. We don't know, we might have kept some other matter as first item. So there cannot be many firsts. On that day, you may make mention to take it up at a fixed time. Yes, Mr. Mandal.
The before that was one judgment, I say,
Now you can make submissions leisurely. What judgment?
Lordship, that is 2022 3 GLT 344. Burden regarding the fake license. When insurance company has taken a stand in
But this is not a fake question of fake license.
not only fake, not valid. Then ownership, we have filed an additional WC, you can note it down, that we have filed an additional written statement after receiving of the Lordship investigation report, that license was not renewed. We have filed an additional written statement and that has been considered by the tribunal. And when that plea has been taken, burden shift to the owner to prove that he has a license. That is his judgment.
Ramesh,
That is 20,
Putul and Ramesh. Be attentive in the court. Judgment 1.
2022, 3 GLT 344, para 11 and 12. But regarding shifting of burden.
Okay, you have mentioned paragraphs.
Lordship.
Okay.
Lordship can, for the appeal and Lordship, his judgment for the appeal.
Yes, Mr. Mandal.
Lordship may not take it otherwise, Lordship. I have only to, for convenience of the Lordship. For convenience of Lordship, I am saying it.
You are only assisting the court.
Lordship.
Yes, Mr. Mandal. Try to finish it
Your
within.
lordship,
You first address regarding the doubt
your
created by.
lordship, so many issues have been raised.
No, one doubt that has been raised by the counsel for the appellant regarding signatures of
Your lordship,
claimant number 1.
your lordship, then your lordship come to LCR. Page 43, PWs. PW1, Sushila Devi. Page, start from page 43.
Yes.
Now your lordship will see that in the evidence on affidavit,
She has signed in Hindi.
as well as in the cross-examination part, if your lordship come to cross-examination part. Before the court,
Yes.
in the presence of the court.
Whether this signature tallies with the signature on Vakalat.
Actually, in MSC claim cases, what happened initially, they remain as, but for some purpose, they have to learn writing. That is the problem. That's why they learn later on. There are some issues.
No, actually
some
what
hidden
happens.
issues.
Because
Actually,
of the,
the claimant appear on that day and he signed before the court. So it
in
is-
Vakalatnama, the signatures are
in
same.
the High Court, yes, same. In the High Court, the earlier set of counsel was there. Later on, I was engaged.
Okay.
Now, if your lordship may come to the cross-examination part for the purpose of deduction.
Cross-examination of which witness?
PW1.
Yes.
Last 3 lines, your lordship. The finding of the court is that there is no evidence. I will read, your lordship. My husband also left 5 daughters and 1 son. Last 3 lines, your lordship.
Yes.
My husband also left 5 daughters and 1 son. My eldest daughter is 19 years old. So I adduce evidence in the year 2015. So all the claimants, apart from Sushila Devi, all are minor sons and daughters. Only one son, 5 daughters.
So total 7 dependents. there.
7 dependents are there. So in case of 7 dependent, the deduction is 1/5.
Deduction ought to have been 1/5.
1/5. For that particular purpose, your lordship, I may
Sarla
Verma or Pranay Shetty, anyone I can rely on.
Pranay Sethi.
Pranay Sethi.
And Sarla Verma, okay.
Should I, your lordship,
No,
copy?
you may give.
Copy.
Para 41 to 45.
This is in respect of cross objection.
Yes, cross objection. So your lordship, deduction. Your lordship may mark that part of my cross examination wherein I have deposed that 5 daughters and 1 son, and my eldest daughter is
Yes,
19 years
yes.
old. So from this evidence, it is clear that apart from the claim petition, from this evidence, it is clear that there are total 7 numbers of dependents.
Yes.
So deduction should be 1/5. Now, your lordship, so far, salary is concerned. Now, the question is whether these incentive earnings can be considered as salary or not.
Yes.
Your lordship, for this particular purpose, I will rely upon it is the pair of 16 and 17. 16 and 17. It is not non-reportable, your lordship. It is SCC 2025 INSC 938. Para 16 and 17. Another, your lordship, is Supreme Court Division Bench.
What was held here?
Your lordship, the term income has been defined. What will be included as a component of the salary? The other
So-
parts, other
So whether
allowances.
incentives,
For incentives, I have another case. This is outside the salary. If any bonus or parts or other benefits are given to an employee, it is the income which I receive, and it should be included. It should be included in the salary.
okay.
Your lordship, this is another case. The division bench wherein incentive bonus paid by employer is considered salary under the income tax act, taxable and not exempted as prerequisite for meeting work expenses. This is another judgment. It will hold আপনার 2013 9 SCC 270.
I will give a judgment to this courtmaster next tomorrow or day after tomorrow regarding the incentive cannot be considered. First by the Supreme Court and by this court.
Your lordship, so far some other issues has been raised by my learned friend. Your lordship, this last 2 pages of Sharan Singh, if your lordship goes to this last summary of findings, whether the tribunal have the power as well as the High Court has the power to direct pay and recovery. And Sharan Singh is a 3 judges bench.
No, Saran Singh is with regard to what?
Your lordship,
Pay and recovery.
summary of findings is last 2 pages. Burden lies on whom? Who will prove?
And whether when the tribunal have the power to direct for pay and recovery, why not the High Court? And this is Supreme Court judgment, 3 judges bench. And till date, it has not been overruled by any judgment, any constitutional bench judgment.
Yes.
And
And
your lordship, so far those non-conventional heads are concerned, the Pranay Shetty, as per Pranay Shetty, it is given, but in another case, Magma versus Nanuram, since there are number of dependent is 7, so wife will get consortium, spousal consortium, the children will get parental consortium, all the 6 children, as per this Magma General or Satyendra Kaur 3 judges bench for consortium. So this is for my enhancement part. So far, their DW is concerned, since I have not cross-examined, so only point which I can raise, so far my understanding helps me, is that your lordship Exhibit A.
what is Exhibit A?
Exhibit A is the letter issued to their investigator by the DTO, by which the DTO gives a report that the license was, the license expired.
Valid up to so and so.
So and so, and it expired. So at the time of accident, the validity was over. Now that contents, that part, as per Evidence Act, that part has to be contents of those writing or those statements should be proved by its author. In that regard, the court is correct. Though they have someone that has been rejected, but that ground has not been taken. So only to this limited submission, your lordship. So my submission is that.
What is your submission regarding?
My submission is that since no person from the DTO, as has been opined by the tribunal.
But court made an wrong observation in the
Yes,
judgment.
in the judgment.
It is the court which rejected the prayer for,
Rejected the
but
application
in the judgment it has observed otherwise,
that failed to examine.
failed to examine. What would be the impact?
Your lordship, that part can be ignored. Your lordship can ignore that part. They have made an effort to call the DTO. And your lordship, in recent, there are some. Your lordship, there are recent 2 judgment of Supreme Court. One is of September 2025. Another October 2025, wherein the pay and recovery has been given.
No,
Very
that
recent one.
the submission is, that power is there with the Supreme Court.
No, your lordship, I have given that.
Saran Singh.
Saran Singh says tribunal can direct.
Okay.
If the tribunal can direct, there are some other cases also where Supreme Court also says that.
And a larger bench has been constituted to look into the matter.
Your lordship,
But
so far,
it is not yet.
since this is 3 judges bench.
So a larger
So
bench.
larger bench judgment is already there.
No, the submission.
Other 3 judges bench judgment is also available. On
So
pay and
a
recovery.
bench larger than that would be necessary.
Yes, larger than
to-
that. Now, for the time being, Saran Singh can be followed.
Okay.
So now my question is that recently also in Your lordship, my learned friend has referred that judgment of which KTR judgment, এই তার পিছু দেখলো judgment টা। এই to 25 ওর দিয়ে যেতে যেতে payment recovery. So in 2024, that judgment was of 2024. In 2025, pay and recovery has been given. This is 1 October, 1 September this year. Sorry, last year. Your lordship may take it.
No, but that pay and recovery was given by Supreme Court.
No, no, tribunal can.
No, no, that is okay. But in the cases which you are referring, in these two cases, it was the apex court which passed the order of pay and recovery. Or whether it observed that the tribunal can also pass such an order.
No, in some of the cases, High Court, even High Court allows pay and recovery. And that got challenged in Supreme Court, wherein Supreme Court upheld the High Court judgment. Pension has been reversed. It is considered a permit from And 142, so far I understood, 142 Supreme Court uses that power when supposing there is no policy. In that case, the Monwara Begum, one case of this High Court also, supposing insurance company is not at all liable, the policy, for some reason, the policy is not effective on that date. In that aspect, 142 is applied.
Under what provision High Court can pass an order of pay and recovery? Swaran Singh.
Swaran Singh, there are many other three judges bench judgment. I can give you a list of at least 10 to 12 three judges bench.
Okay.
In every case is pay and recovery. The requirement is that the insurance company should able to prove that the violation was willful. Here, since there is no cross-examination on our part, so their deposition is totally acceptable as a evidence. So my prayer is that so far enhancement is concerned, the deduction should be 1/5. And the incentives, your lordship, if your lordship go through those incentives, in some month I have paid income tax up to 15,000. So if I am paying income tax on that incentives, why that cannot be considered as my income? I have paid income tax of 15,000, 13,000.
Cross objection. Okay, anything else?
Okay. Your lordship, exhibit 373633. In this exhibit, in the bottom part, in the incentive part,
yes.
Exhibit 33, I have paid in, the deceased have paid income tax of 15,000.
3733 and
No, 333637. In 33, in 33, I have paid 15,000. In 36, I have paid 13,700, 900.
okay.
So if income tax is deducted from that income, so it is my income. And there are judgment also, your lordship, I have referred, wherein one judgment of LIC and versus LIC, I think it, that judgment clarifies that incentives are also part of salary. And as per income tax act, it is also a part of salary. And it is taxable. And I have also duly paid the taxes. So my salary of March 2013 should be taken as my income, including my incentives. Because March, because in the April, there are some, one thing here is an accident. So 4 days. So March may be taken. March 2013 salary. That is my full salary.
Why?
Your lordship, I met with an accident on 26th April. So there will be shortage of 4 days. So
Okay. Anything? Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard Mr. D. Mondal, learned counsel for the respondent claimant as well as the cross objector. I'll dictate for 5 minutes. You may take your seats.
thank you.
By this common judgment, this court intends to dispose of the MSc Appeal number 95/2017 filed by the insurance company, namely Oriental Insurance Company Limited, as well as the cross objection number 14/2019 filed by the claimant respondent, claimants respondents, namely 1, 2, 3, 4, 5, 6, 7, 8. The facts relevant for consideration of the instant appeal as well as cross objection are that ... Stop. Learned counsel for the appellant at the beginning of his making his submissions has pointed out to this court that in the before the Motor Accident Claims Tribunal, Kamrup number 2, in the MSc case number 1218/2013, the claimant number 1 had put her left thumb impression, whereas before this court, while filing cross objection as well as in the instant in the MSc Appeal 95, she has put her signatures, which according to learned counsel for the appellant is a matter of grave concern, and which raises doubt regarding the identity of the claimant. Stop. On this aspect, learned counsel for the respondent number 1, respondent number 1 to 7 / cross objectors has submitted that though it is true that the claimant has put her thumb impression in the Wakalatnama, however, while giving her testimony as PW1 before the tribunal, she has inscribed her signatures in Hindi on the deposition form, and the said signature tallies with the signature given by the claimant number 1 in the Wakalatnama before this court. Hence, he submits that there is no dispute regarding the identity of claimant number 1 in this case. Stop. Learned counsel for the appellant has further submitted that the trial court, further submitted that the Motor Accident Claims Tribunal had erred in holding that the insurance company failed to show that the driver of the offending vehicle was not. Oh, yes. Oh, sorry. Miss Endeka appears for respondent number 8. And Miss J. Bushu appears for respondent number 9. Last link, yes. I'll dictate it in chamber. Yes, you give that judgment. What is your submission? You are the owner.
To identify that particular fake news
So what is your submission?
pinpoint one particular point we have achieved. The particular aspect is that even though the main problem is that the due diligence of the owner should also be considered, but in this matter, Your Lordship, it was not considered. And if we examine the cross-examinations, even the defense witnesses also, nowhere they have mentioned about how the owner was neglected to fulfill his duty to verify the authenticity of the nowhere.
You have adduced any evidence? Have you adduced any evidence? Their submission is that burden is first on, that is their submission, that to show that you were diligent in verifying the license is valid or not, you have the burden. Once you relieve that burden, it shifts to the insurance company. That is the submission made by the Mr. It proceeded ex parte. Who is 9? 9 is owner, driver. Okay. Yes. Yes, but here the lapse was of 3 years. Okay, I request all of you to submit, both of you to submit written gist of your argument, as you could not make much submissions.
Lordship may record his submission, Lordship, regarding the Lordship, he, because of the irritated person, he failed to renew the license in
No,
time.
let them submit written gist. Heard Mr. S.K. Goswami, so and so. Hearing concluded, judgment reserved. Learned counsel for all the parties are requested to submit a brief written gist of their respective submission within a week from date of this order to the court master of this court.
So Lordship, second week is view vacation. More time may be granted.
Before 30 January.
Yes.
Verification, before verification is better, Lordship. Lordship can see the file. Verification.
Yes, you can submit before 9, if possible. Both of you, your submissions, I have made my notings. So it is for them mainly because they could not get. But if possible, you can also submit.
By?
By what would be convenient for you?
Immediately after opening.
Okay, okay.
19.
Highly appreciated.
Before 19.
On 19 year Lord.
Save.
On 19.
On 19.
Opening day.
Or
We'll give the registry.
it should not be, it will not be listed again.
Court master.
No, your Lordship.
Court master.
You have to give it to court master on 19.
Highly obliged.
Highly appreciated.